Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Michegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcake's sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Just another manic Monday. Just another manic Monday. I don't know. Did I call it? Did I call it on Friday night's show? Was it Friday night? What night was it that we did the really long show and then buried the lead about Proctor's phone extraction that was just ordered in August of 2025? In which the Commonwealth received his entire phone dump going all the way back to 2013. Has anybody else even covered it? Has anybody else talked about it? Yeah, that's what happened. And I had my whole week planned out. Tomorrow I was going to do Proctor's termination hearings with you live, Tuesday, Wednesday, Thursday. But what happened was Proctor quit. He withdrew his appeal to get his job back. Ted Daniel just broke it, and like 14 of you guys sent it to me. So let's take a look. So there will be no hearings Tuesday, Wednesday, Thursday for Proctor. Kind of frees up the week a little bit. And I don't know. I think I kind of predicted like something crazy was going to happen, right? That this was going to be a much bigger deal than we thought. Because in case you missed it on Friday, there was a filing in the Brian Walshe case. There was a filing in the Brian Walshe case by the Commonwealth. And in that filing, the Commonwealth said, Judge Krupp, we need more time to go through Proctor's phone dump that you ordered in August of 2025. Because when you ordered his phone dump in 2025 and you ordered Proctor through his attorney to turn over his phone to us, Proctor's attorney said to us, you're not going to get a lot of stuff. You're not going to get much because Proctor got a new phone in February of 2024. And when he got his new phone, he set everything on his phone to auto delete every 30 days. So you're not going to get much. The most you're going to get maybe is the last 30 days of material. And, maybe because Proctor was trying to get his job back, he cleaned his act up and he was like, tightening up his game, on his phone. And so there was nothing in there in the last 30 days. But what had happened was the Commonwealth said through Greg Connor, who has a lot of integrity, he may be one of the few in the Norfolk DA's office who has a lot of integrity, said, Your Honor, we need more time. I think there was a deadline of October 26th for the Commonwealth to turn over to the defense everything that was relevant from Proctor's phone dump. We need more time because there are still hundreds, not still, but there are hundreds of thousands of messages and hundreds of thousands of pieces of data between text messages, other kinds of messages, emails, photos, video and audio files. They said, Your Honor, we think we can meet the deadline with regard to the texts and chats and video and audio recordings, but we need more time to go through the photos and the emails. And it was explosive. And you could see it. You could see it because everyone out there, many people out there are coming for me on social media on the cesspool that I choose not to participate in. And is it because I was getting a little too close to the truth? But I have zero credibility, I have zero credibility. So don't listen to me. But here's what Ted Daniel posted 16 minutes ago. A little bit before that, he said, breaking, Michael Proctor, 29 minutes ago, breaking, Michael Proctor's attorney, Daniel Moynihan, confirms for me that Proctor has dropped his appeal to get his job back with the state police. And then 16 minutes ago, Ted Daniel said, here's the paperwork from the Civil Service Commission showing Michael Proctor is no longer seeking to get his job back with the Massachusetts State Police. Proctor was scheduled to have 3 days of hearings beginning tomorrow. Those are canceled. Let's take a look at the withdrawal of Civil Service Commission appeal, which has just been published. And here it is. And it's dated, this is a really bad copy. It's dated October 18th. Today is October 20th, 2025, which means that this was signed by Michael Proctor on Saturday. On Saturday. And it says, has the case number, and it says withdrawal of Civil Service Commission appeal. And it's on Civil Service Commission letterhead. It's got his case number. It says Michael Proctor, appellant. And then it says, it's hard to read, I know, because it's kind of a fuzzy copy. Versus the Department of the State Police appointing an authority. It says this notice confirms the withdrawal of any appeal, or of my appeal, I think it says. I don't know, it's hard to read, wait. This notice confirms the withdrawal of my appeal in the above referenced matter. I exercise my right to sign this form of my own free will. XOXO, Michael Proctor, dated October 18th, 2025, which was Saturday. Everything else is redacted because, Ted Daniel is a reporter and that's what he does. And so that's it. That's it. Proctor quits. He waved the white flag, coincidentally, one day after, I don't know, the news was broken that the Commonwealth was in possession of his entire phone dump going all the way back to 2013. And isn't that when he became an MSP police officer, around 2013? And for those of you who didn't see the document that we went over on Friday, I'm going to pull it up again so you can take a look at it for yourself because, we like receipts. And it was filed in the Brian Walshe case, which is why it might have escaped attention. It wasn't filed in Aidan Carney's case. It wasn't filed in any non-existent Karen Reed case right now, except for the search warrant case that they're trying to get Karen's phones. And so here it is, because at 2 o'clock we're gonna watch the Brian Walshe hearing, but the hearing at 2 o'clock is the hearing with Myles King, Brian Walshe, and that has to do with the federal materials. That is something totally different. They've been fighting in front of Krupp to get Proctor's messages unsealed by the federal court. But those are all the messages that were turned over by the feds to Karen Reed's defense team in the Toohey dump prior to trial 1. This is something totally different, okay? So I'll pull it up for you so that you can understand a little bit better exactly what I'm talking about in case you missed it the first time. And this is a document that was filed by the Commonwealth October 15th. It didn't land in my inbox until Friday, which was the 17th. And that's the night that we went over it. And I don't know what day it was scanned. I'm pretty sure it was only scanned that day, but I'm not quite sure. And so here's the pertinent part. Well, I might as well read the whole thing to you so we don't just cherry pick the parts that we read, okay? And this is filed by the Commonwealth in Brian Walshe's case. Pursuant to orders in Commonwealth versus Myles King and other cases, the Commonwealth began examining an extraction from a personal cell phone of former Trooper Proctor for information reasonably believed to be discoverable under Rule 14. Rule 14, as you know, is automatic discovery, and that is stuff that the Commonwealth or the prosecution must turn over to the defense automatically under the rules of procedure and evidence. Due to the unexpected volume of files discovered on the cell phone, review of the extraction is not yet complete. So they're asking the judge for more time. The Commonwealth is attempting to produce information it currently believes to be discoverable by October 24th, 2025, but requires additional time to complete its review of the data extracted from the cell phone. So Judge Doolin, not Judge Doolin, I think it was Judge Krupp, set a deadline of October 24th for the Commonwealth to turn over this stuff that was relevant to the defense in the Walshe case. On June 17th, and we know because we've seen Laura McLaughlin in hearings in open court over the summer tell Judge Frenier that she has reviewed whatever extraction they had at that time and that she believed that some of it actually was relevant to Brian Walshe's case. And that is not including this dump, I don't think. It was before that because I remember that I was in New Hampshire when we did that stream. Remember where I was? It was in the summer. On June 17th of 2025, Norfolk Superior Court Judge Michael Doolin allowed in part Defendant King's motion to preserve and produce former MSP Trooper Proctor's personal cell phone, ruling, quote, as to the communications, including the content, call duration, times, and numbers involved on former State Trooper Michael Proctor's personal cell phone from the date of the charged murder in the King matter to the date of the indictments. So Doolin limited it in the King case from the date of King's indictment, from the date of the murder to the date of the indictment. And he went on to say, Doolin said, the Commonwealth shall promptly produce any other data from Proctor's personal cell phone that constitutes investigative materials or is favorable to the defense within the meaning of Rule 14. And that was Doolin's order of June 17th, 2025. Judge Doolin further ordered that the Commonwealth may move for appropriate protective orders for the court's review prior to producing information, and that defense counsel shall not show or provide the communications produced pursuant to this order to anyone else except the defense counsel may show but not give them to the defendants in this case. Now, Proctor's attorneys filed a motion for clarification, and this set off a whole new chain of events. So, upon filing of a motion and amended motion for clarification by Proctor's counsel on August 13th of 2025, so Proctor's attorneys filed a motion on, August 13th. Did I say October? August 13th of 2025. Norfolk Superior Court Judge Peter Krupp clarified. So now they asked for clarification, and Krupp clarified by saying the obligation to produce any other data that constitutes investigative materials or is favorable to the defense is not limited to a particular date range, and that Proctor had a legitimate interest in protecting attorney-client or spousal communications. So Proctor's attorneys, by making that motion, caused Krupp to open up the floodgates. Krupp just made his legacy, says Anne. Oh, no. He says, I'm not limiting it from the date of the murder to the date of the indictment. Oh, no, everything is fair game. Okay. Judge Krupp ordered that and this is on August 13th, that by certain dates, number one, Proctor provide his cell phone to the Commonwealth. Number two, the Commonwealth extracts a full digital copy of the cell phone and then provide a copy to Proctor's counsel for a privilege determination and return the cell phone. Okay, so I don't know exactly when the Commonwealth turned over the full extraction to Proctor's attorneys, but I bet that whatever was contained therein had something to do with him withdrawing his appeal to get his job back in front of the commission. Number 3, counsel provide a privilege log to the Commonwealth. And 4, the Commonwealth shall search the cell phone extraction with the exception of the communications identified on Proctor's privilege log to locate the information authorized by the initial order as clarified herein. By October 24th of 2025, the Commonwealth shall produce to Defendant King and others, okay, so today's the 20th, so in 4 days, the Commonwealth shall provide a copy of Proctor's privilege log, if any. And so just to clarify, anything privileged would be a one-way ticket to Vietnam. Is he getting on a plane to Vietnam? Anything privileged would be attorney-client communications, any communications between Proctor and his attorneys, and perhaps any communications between Proctor and his wife. If you can think of any of the privileged communications, let me know. Maybe some health, if you had any health information on there, that could be privileged. Hold on. And all documents required to be produced under the initial order as clarified herein, except for those documents identified in Proctor's privilege log. Okay. So the Commonwealth was ordered by Judge Krupp that in the next 4 days, by 4 days from now, the 24th, they were to turn over everything except for what was privileged to the defendants, including Brian Walshe. The Commonwealth proffers, okay, so the Commonwealth is telling the court that it has received Proctor's cell phone, so they got the cell phone, that an extraction has occurred, that the phone was returned to Proctor, and that Proctor's counsel provided a document entitled Privilege Log on the court-ordered date of September 26th of 2025. The extraction has yielded hundreds of thousands of items, some of which are dated as far back as 2013. Hundreds of thousands of items. The volume of items was unexpectedly larger than the representation of Proctor's counsel regarding the cell phone. Footnote 2. Proctor's counsel on July 25th of 2025 and August 12th of 2025 filed an amended motion for clarification, which noted that Proctor changed phones in February 2024, did not preserve his old phone, and after activating his new phone in February of 2024, used an auto delete feature, deleting the contents of his phone every 30 days. He got a new phone in February 2024. What happened in January 2024? Does anyone remember? In January of 2024, that's when I think it was Tully and Fanning showed up at Karen Reed's house to seize 2 additional cell phones from her to try and indict Karen and Aiden on new conspiracy to commit witness intimidation charges. And then the next month, Proctor gets a new phone. And Proctor's attorneys tell Judge Krupp, yeah, well, here's the thing. We need clarification on this because Proctor got a new phone February 2024. After that, everything auto deletes within 30 days. So you're not really going to get much. You're not going to get much, maybe 30 days worth. And then his attorneys doubled down and said, counsel proffered, it says in footnote 2, therefore, regardless of the timeframes for this court's order to be clarified, it is unlikely that Mr. Proctor has any relevant information in his possession concerning this case. Well, you wrong. You wrong, Proctor's attorneys. You wrong. It's all happening. But wait, because it gets better. Review of the extraction is underway, and the Commonwealth has identified materials that it reasonably believes to be discoverable under Rule 14 in the King matter and in other cases where Proctor was a witness. I pointed this out. In which cases did Proctor testify in front of a grand jury? Karen Reed's case? It doesn't say in other cases where Proctor was a lead investigator. Word choice is very important when you're an attorney. Attorneys choose their words very carefully. Other cases where Proctor was a witness. And then, as I pointed out the other night, they cite a case called In the Matter of a Grand Jury Investigation, which stands for the premise that disclosure of exculpatory information arising from unrelated grand jury proceeding, part of prosecutor's official duties, and may be disclosed without order of the court unless prosecutor seeks protective order limiting disclosure. Wow. Proctor testified in front of the Karen Reed grand jury to upgrade her charges to murder 2, right? He also testified in front of the federal grand jury, didn't he? And what other grand juries did he testify in? Anyone? I'm not sure if he testified in Aidan Carney's grand jury. You can tell me if you know the answer. Things that make you go, But that's not all. Because the Commonwealth, and this is not LALLY, goes on to say, in addition, where appropriate and consistent with the Commonwealth's obligations, because they know their obligations under Brady, the Commonwealth will, not may, will produce pertinent information to individual law enforcement agencies. All of them. Name them. The FBI, individual law enforcement agencies. Footnote number 3, which says, in accordance with the court's June 17 order in King, the Commonwealth will move for a protective order to release prior to release of the materials to counsel in this case. So they're going to move for a protective order. They haven't turned it over to the defendants yet. But it's going to be explosive. And based on the fact that MICHAEL Proctor has just withdrawn his bid to be reinstated, maybe either Proctor's attorneys knew what was in it, or some of that information was turned over to the Civil Service Commission or whoever it was that was, I think it's the Civil Service Commission, right? That was handling his appeal. Maybe some of it was turned over to those prosecutors, leading to him on a Saturday to sign a withdrawal of Civil Service Commission appeal. David Reese says only Tully testified at Aiden's grand jury regarding all of the witness intimidation cases, because he's had more than one grand jury, right? I mean, he's had grand juries for all of the witness intimidation cases regarding the rolling rally and other things, right? That was the first one. Then there was one that didn't return a true bill, trying to indict Karen and Aiden for conspiracy to commit witness intimidation. And then wasn't there also a grand jury on the Lindsay stuff? So I think there were 3, and I don't know, but no, for the first grand jury, didn't I think Proctor had to testify because Proctor was a victim in that case when Aiden did the rolling rally past his house, right? But I'm not sure, because you guys might know a lot more than me, because a lot of you guys follow or have watched every one of Aiden's streams, which I don't have time to do. Yeah, for witness intimidation, right? The first one. Didn't they all didn't he and Elizabeth both testify? I mean, they were both victims. Oh, sorry, if you guys are late, Proctor has withdrawn his appeal. I'll put that up again in a second. And so this filing in Walshe goes on to say that, listen, we need more time. We think that we can get all of the texts and chats and video audio files to the defendants by October 24th, which is the deadline, but we need additional time to comply with the order in King and other cases to review other files on the extraction from Proctor's cell phone, including emails and photographs. Emails and photographs. Oh boy. Oh boy. Are the walls coming crumbling down? Oops. Who was he emailing? I mean, we know there are certain witnesses that had like a direct line to Proctor, right? And Buchanan, what if he took a photo of the taillight in Karen's parents' driveway? What if he did that? What if he took it and it was intact? What if that's on his phone? I mean, could it be? I have no idea. He found out that his phone is telling them everything. Yeah. XOXO. Greg Connor. There it is. He's not going down with the ship. Greg Connor is like, I'm not going down with this ship. I'm not losing my bar license over the shenanigans that have gone on during the persecution of Karen Read and that apparently continue to go on. And here it is. If you're tuning in late, Ted Daniel broke the news. There were supposed to be hearings tomorrow, continued hearings, because I think there's already been at least 2 days of hearings, maybe 3, in front of it's the Civil Service Commission, I think, to get his phones back. I mean, not to get his phones back. He already got his phone back. He got his phone back right away, probably within 24 hours, to get his job back. Here it is. Withdrawal of Civil Service Commission appeal. On Civil Service Commission, led ahead with his case number, Michael Proctor, appellant, versus the Department of State Police appointing authority. This notice confirms the withdrawal of my appeal in the above referenced matter. I exercise my right to sign this form of my own free will. XOXO. Michael Proctor, signed October 18th, 2025, which was Saturday. So the hearings are done. He quit. He's waving the white flag. Does it have something to do with the phone extraction? Maybe. Maybe. I mean, you know what they say. If she takes a plea, it'll be all over. But if not, it's going to be a whole new episode. Welcome to the prequel of season 3. Well, you can never tell. Let's go to the chat in a second. I just want to, I want to get the Zoom up for the hearing that's supposed to start at 2 o'clock. I started early. Sorry if you had your notification set for 1:45. This news just broke, and so I wanted to get it to you before we started on the hearing. So talk amongst yourselves for a second while I log into the Zoom. If you are personally logged into the Zoom for Judge Krupp, kindly make sure that you are muted so that they don't hear me talking on the stream, because it's happened more than once. All right, let's see. And this is a hearing on the Myles King, Brian Walshe, and other cases. And this is regarding the federal materials, just so that we're not confused. What are we going to do for the next 3 days? I got stuff. I got a whole Oklahoma show planned for you. We're going to go to Oklahoma. There's a bunch of stuff to cover there, including Grandma Tiffany Adams taking a plea. And there's another horrific case in Oklahoma, some OSU football coach's son who did some horrific things to a couple of girls, and he's getting away scot-free. Hold on. Oh, excuse me. Pardon me. Pardon me. Excuse me. Okay. Hold on a sec. Things are breaking like crazy. Just breaking like crazy. Yeah, and Boston 10 already has an article up on their website. Former trooper Michael Proctor, the lead investigator in the Cannery case, is no longer appealing to be reinstated to the Massachusetts State Police following his firing, his attorney said on Monday. Proctor had been due for several hearings this week before the Massachusetts Civil Service Commission in that effort. 2 hearings have already been held in the matter. Okay, so it was 2 hearings. And Proctor's side had been expected to focus on disciplinary records at the next one. But Proctor attorney Brian Moynihan said Monday that the team withdrew the appeal after receiving a recent disclosure from the Norfolk County District Attorney's Office. He didn't share details on what the disclosure was. Well, Ted Daniel, if you were watching my show, you would know. You would know what the disclosure was because I just went over it again for the second time. Proctor was also the subject of a hearing Monday involving several other high-profile cases in Norfolk Superior Court. Watch that hearing set for 2 p.m. in this article on the NBC Boston YouTube page. All right, good. We can watch it through YouTube, which means that that we don't have to go into the Zoom. Yay, Boston 10. Thank you for doing the Lord's work. But you would know what that recent disclosure was if you were watching my show. Yeah, there it is. I mean, you can't make this up, you guys. You can't script this any better. Like, there's no Hollywood production that could be even better than what we are watching in real time. Would you agree? And then it goes on to say, Proctor was found guilty. Oops. Proctor was found guilty by a state police trial board in March of 3 counts of unsatisfactory performance and 1 charge of alcoholic beverage leading to his firing. Yes. Remember when they were chasing down that cold case of Heine's on the Cape, him and Kevin Albert? And the next morning, Kevin Albert woke up and was like, dude, where's my gun? Dude, where's my gun? I can't find my gun. Dude, where's my badge? I can't find my badge, dude. Where's my badge and my gun? That was Kevin Albert that lost it. I think all of them are losing a little more than that today. State police called only 1 witness to the stand at the first hearing in August, Lieutenant Kevin Dwyer of the agency's Office of Professional Integrity, who investigated Proctor's conduct. The next day, Proctor's attorney spent hours cross-examining Dwyer. They contend the state police picked a fireable offense and then did the investigation. The findings of Dwyer's investigation, text messages Proctor sent, and the fact that he was drinking and driving a cruiser while on duty led to Proctor being fired in March. The firing came after a months-long suspension, which was handed down days after Karen Read's first murder trial ended in 2024 in a mistrial. Yeah, people are saying Kevin Albert should have been fired. I mean, didn't he lose like 3 vacation days though or something? I think he lost like 3 whole vacation days. So did you not think that was enough of a punishment for Kevin Albert? Boston, Mass. 781 says that 2020 interview Proctor did crying for his job is looking even more cringe right now. Oh yeah, we have him as a mascot from that interview. That's, I think, from that interview when he went on his, apology tour. His apology tour. Right. Who would have thought Judge Krupp would be the one? I bet he didn't know the Pandora's box he was opening. No, Carol, I agree with you. And also, do we think that he's going to allow a total extraction on Karen's phone that they had since 2024? Even though it is my understanding that Judge Cannoni has already ordered the release of her property, including those phones, which, by the way, was not argued by Karen's attorney, Buzang, at the last hearing. So I'm confused by that. It should have been, in my opinion. Mama B became a member. Welcome. Mary Malarkey. Ted Daniel News, MICHAEL Proctor's attorney, Daniel Moynihan, confirms for me that Proctor has dropped his appeal to get his job back at the state police. Thanks. You sent this earlier before I even went live. Thanks, Mary. Kelly Applegate gifted a membership. Thanks, Kel. And OnlyFan has been here for 2 months and says, proctored. Doctored, proctored, tullied, and sullied. And the band keeps playing on. Kelly Applegate says it's going to be a great Monday. It's a Monday fun day. It's Monday fun day, Kelly. Thanks for your super chat. Music to My Soul says Proctor must not have known all that was still on his phone. I guess he didn't want to draw more attention to it. So glad he withdrew his appeal. I think there was no chance in hell that it was going to get granted, but I think this kind of seals the deal, right? This sealed the deal. So hence the withdrawal quickly on Saturday morning. And hence all the trolls coming after me. So if you know, you know. Right on. Coffee Girl says, shout out to my Auntie Lynn watching. Hey, Auntie Lynn. Thanks for your super chat, Coffee Girl. And Life Goes On says, Proctor goes down in flames. What a shame. What a shame. Oh, Emily, see, your brother just had a baby. Your brother just had a baby. Can we see the baby? Can you email me pictures? I'm not going to show them on the air, but I just love pictures of babies. They make me happy. Today is a great day. Congratulations to your brother, and congratulations to you, Emily, on your first nephew. Goes down. The walls are crumbling down. The walls come crumbling down. Everybody go back to the Karen Read playlist because it's becoming even more pertinent now. Right? On point. Instant karma is going to get you. Bye-bye, Mr. Pay, says Helena. Thanks, Helena, for watching from Sweden. Reasonable AF. Good to see you, too. Thanks for being here for 10 months. And Tony says, what are we going to do for the next 3 days? Oh, we got stuff. We got so much stuff to do. Don't worry. I think more stuff is going to explode on this, too. And that's why you always got to be prepared in the YouTube world for the breaking news, because good thing I already had this planned. And then a lot of you guys are already waiting. And so here we are getting it done. Tracy from Florida says, all right, let's see. They're getting their feet up, kind of. We need Tully's phone. All roads lead to Tully. Yeah. All roads do lead to Tully. You know it. I know it. We know it. We've been watching. We've been watching from the beginning. I mean, crazy town. Thank you, Tracy from Florida. Free super chat. Lucy says Karma cupcakes are delicious. Elf says, I'm so lucky to have found you during Karen Read. Thank you, Elf. I appreciate all of your kind comments. They almost drown out all of the hate. Almost. Just keep spreading love, you guys. Just keep spreading love and empathy, and you'll be a much happier person. Nicole says, did you see the guy in Maryland that hit 14 people on Saturday, including 8 children, going in reverse? No, I did not. Did not see that. Susan became a member. Welcome. Arlene says, you called it Friday. Facts. Love you. Love you too, Arlene. Thank you. 20 months. You're an OG. Alicia became a member. Welcome. Amanda says, do we think eventually Proctor will be charged? I mean, stranger things have happened. Listen, here in New York, there was just a guy arrested last week for a murder that was 40 years old. 40 years old. So time will tell. Thank you, 617, Amanda, for your super chat. And Inverted Sneaker says, hi, Melanie. Let's hope the McCabe's meet Karma soon. Well, Karma knows your address, as I always say. Poca says, I see Proctor flipping on everyone to save his butt. Yeah, I mean, look, I don't know what they're going to find on his phone, but whatever it was explosive enough and damaging enough to cause him to give up his appeal to get his job back. So, read between the lines. Mass Dad, it is the Zoom info. I've got the live up from NBC 10 because they're going to be streaming it live. But the Zoom info that the clerk gave me was for the main room. I think it's in courtroom 25 though. But when I went on the website, the daily list, the calendar on the website is the calendar for the website. On the website is Friday's calendar. They didn't update the new calendar. Yes, Barbara, he gave up his appeal. You must be late. Rewind. It also is in the title. It says breaking. He gave up his appeal. There will be no hearings tomorrow, Wednesday, and Thursday. He done. He done waved the white flag. Me too. Francine says, I hope the end of this movie reveals who actually took John's life. I do too. Waiting for Boston 25 to get their feet up for the 2 o'clock hearing. It's only 1:55, so we got a little bit of time. They have 90 people watching. We have 7,666. Oh, can one more person join so we don't have a 666 at the end? But it's kind of appropriate because, the devil and all. Salem witch hunts. 19 women. I think it was 19 women were hung in 1692 for being witches in Salem. I think one man was stoned to death, but I think it was 19 women who were hung in town square. Yeah. Yep. Proctor withdrew his appeal. I've covered it. I've covered it. All right, good. Now we have more. 7705. All right, thank you. Thank you. Colleen says, I really hope Buchanan doesn't get moved to Western Mass. Thanks, Deidre, for becoming a member. Christmas came early. Mrs. Bouquet says, I love you with all of my heart, too. Kay Willis is here. She has a feeling that a lot of people may be selling their houses south of Boston. And so if you need a realtor south of Boston, Kay Willis is your girl. And look, she just gifted 5 new members. Welcome. And Bruins fan became a member. I'll allow it. Even though I'm a Rangers fan, I'll allow it. And Lauren M became a member. Welcome. It's going to be a whole other episode. Oh, you did, Christine? I was thinking of doing some stuff on the Salem witch trials before Halloween. She says, Christine said, we did mock witch trials in my 7th grade social studies class. I still remember it. Turtle Boy is saying that his sources are telling him that King is going to walk. Well, that'll be interesting. I just got a new filing in King that it's 9 pages though, so I need to read it before I can tell you what it's about. So while we wait for the feed to come up, let me see if I can find it here. Talk amongst yourselves for a second. Oh, this has to do with that. Remember the evidentiary hearing that was in progress when LALLY was on the stand in the Myles King case? And LALLY was being questioned about why he didn't turn over search warrants for 6 years in the Myles King case that he had in his possession for 6 years. And then LALLY was under crossing. I don't know if he was being crossed. LALLY was on the stand and Proctor was present and he was in the hallway with his attorney. And then all of a sudden, Krupp just pulled the plug on that hearing. So there's a filing here. Commonwealth's response to defendant's motion for discovery related to witnesses at the motion to dismiss hearing. So I just have to read quickly through this so I can bullet point it for you. Well, we're waiting for the hearing to start because it's been a crazy Monday so far. Fun day Monday. It's Steph on the Cape says, I just got here and now I am so far behind. Well, Proctor withdrew his appeal to try and get his job back. And we think maybe it's because of what we discovered on Friday about the total phone extraction on Proctor's phone going back to 2013 with hundreds of thousands of messages on it. Hundreds of thousands when his attorneys told the court and the world that Proctor had his phone set to delete every 30 days. And so they weren't going to find much on his phone at all. Yet, you're wrong. The Zoom is up, but Boston 10's feed is not yet up. I don't have a producer. It's just me. It's just me and you guys. So I do everything myself. So you just got to give me a minute. Yes, thank you, Jinx. Salem witch trials says 19 were hanged, 5 of which were men, and 1 man was pressed to death. That's what it was. He was pressed to death, right? Not stoned, but pressed with stones. Did stones have something to do with it? Because I wanted to do a Salem witch trial show before Halloween, and I started digging into it, and I found like all the original documents, and the court reporters were documenting things in like pen and ink, you know, like an inkwell pen. Crazy. Big Pork Chop 81 surmises that Proctor's phone is going to implicate a whole lot of folks. Mr. Monk's understudy, did law enforcement take Kelsey's phone ever? I don't know. I'm not sure. I don't recall covering that part of it. I don't know how it would be relevant. Lily said, I'm surprised they had court reporters back then, Mel. You know what's interesting is they had, I mean, from the limited time that I had to spend on it, I found the archive of old documents, and some of the hearings or the trials had 2 court reporters doing it. I guess so that nobody missed anything because, you know, they were writing everything down as it was happening. They did. And it's on like parchment paper with pen and ink. And they did. They took great records back then. Beth Allen said, I recently read a book, Killing the Witches. Good read. Thanks. I'll check it out. Sherry Thompson became a member. Welcome. Krista says, my day started with digging through our trash, looking for my car keys, which were found. Congratulations. Day made better once Melanie went live, and I learned there's way more important trash to talk about and take out. I know. This is the stuff that needs, you know, this is the content that I want to do. Not that, I mean, this is drama, but it's drama in a legal way. It's not drama like who's fighting with who. I don't have time for that stuff. My time is limited. And yeah, way more important trash to talk about. Heather says, I'm here for all the good things to come. Thank you. Thank you for watching. Kath became a new member. Welcome. Michelle, thank you for your super sticker. I see the bench. It's in courtroom 25. But the courtroom, the Zoom information they gave me was for courtroom 1. Wildlife lover, welcome. In UK, Craig, welcome.
You do feed this back top, right?
All right. So the court's now in session. You may be seated.
We're going to start with number 12, Commonwealth versus Kevin Moore, 24 CR 214. Mr. Moore is not present. His presence was waived by his attorney, Scott Murphy. The Commonwealth is represented by Assistant District Attorney William O'Driscoll. The matter is on for status. If the parties could please identify themselves for the record.
Oh, it's Margaret, the court clerk. Okay. But we're going to hear other cases first. So let's hear how the Judge Krupp treats the other defendants, okay?
Okay, what are we doing today?
So I received about 12:30 today a motion for a buccal swab along with the DNA report that we've been waiting for quite some time. I just need a brief time to file my opposition, and we're going to have a hearing on that. I think we talked about November 3rd was the day the court was available, and we were available.
Great.
So I'll file my opposition. I can file it by the end of the week.
We'll bring your client in for that date.
Yes,
If a
please.
buccal swab is allowed, be done on that date. Okay?
So as Mr. Moore, it's continued to November 3rd at 2 p.m. for hearing of the Commonwealth's motion for DNA. Thank you.
Thank you.
Is Ms. Yass still here? We have 88.
She's in the back.
She is, okay. This is number 11, Commonwealth versus Tristan Smizer, 23 CR 159. Are we ready on Mr. Smizer, or do you want a second call? No. Mr. Smizer is not present.
He's not here yet. Your Honor, good afternoon.
Good afternoon.
Bethany Rogers on behalf of Mr. Smizer. He just sent me a message, and I was just replying to him about court today. So.
Okay. He's on his way. Should we wait?
No, he's here.
Okay, great.
Perfect.
Mr. Smizer, come on in. Your timing is impeccable. Okay, what are we doing today, Ms. Yes?
Your Honor, you had set today as a date for the Commonwealth to file a certificate of compliance, which I have.
Okay.
You had also set today for the Commonwealth to file a motion for reciprocal discovery, which I am.
Okay.
I am also filing a notice of discovery 6 and a notice of intention to introduce medical records.
Is the court volume okay for you guys? What happened to the camera? It's Judge Krupp.
I'm trying to understand your certificate of compliance.
Commonwealth to file
The camera just went black, but it's not the right case yet anyway.
After quoting rules, you say we have provided them with certain things. It looks like the only thing is left.
This is the Zoom.
that done. I sent out, I sent out the summonses, and with the summonses, I sent out specific requests to both the lab and the police officers for them to answer our specific questions. I've already checked with our office and to see if there was any information that our office contains and if Post contains about pursuant to Graham McFarland. I've turned that already over to my sister, so I've complied with all of that. So now I'm just waiting for specific responses. I've received actually a majority of those, and so far
They're getting back to the my sister, my brother language. I've turned it over to my sister. Sometimes they say that in Massachusetts. They call opposing counsel my sister instead of my adversary or defense counsel, my sister.
I don't have any. Put in most of the motions that I for an end of April trial date.
Do we have a date in the end of April? Did we schedule it?
We do.
Okay. All right. Anything else we need to do today?
I think the only thing we need to do is schedule a time for the reciprocal discovery motion.
Well, is there any opposition to the reciprocal discovery motion?
I just gave it to her, so
I
I
know.
don't think she's even had a chance to read it.
Okay.
Potentially, Your Honor, and if there is, I may even want to file something in writing, so I
Okay.
would like some time.
The date in 30 days from now, sometime before Thanksgiving, maybe? November 2021?
I believe the conference November.
Oh, 20th is the conference, that's right. Uh-huh. But 21st is available, or we could do one of the sleepy days before Thanksgiving if you're going to be around.
Your Honor, I have a trial that's starting on the 20th, and it may run into the 21st.
Okay.
So,
Want to do 24th? You're going to be away?
I'm actually was hoping that we might be able to do something in the beginning of February.
Is that on Walsh? Is the Walsh case going to go trial?
Yes.
What's your trial date now?
Our trial date is November 18th.
I see. Okay. So when would you like? When would you prefer?
Something in early February, possible?
February 4? Wide open, yeah.
Somebody thinks that's Brian Albert right there. I don't think so. It's hard to see. Got a gold tie on, but I don't think so. And then somebody else is trying to say that that's definitely not Paul O'Keefe sitting over there. Don't know if that's Brian Albert or not. Is anybody in the courtroom?
February 4?
Thank you.
Okay.
Let's not start.
Mr. Smyser, your matter is continued to February 4th at 2 p.m. for hearing on discovery motions. Thank you.
Oh, shoot. Sorry.
Waived. Her attorney, Joseph Cataldo, is present on Zoom. Also before the court, number 8, Commonwealth versus Giovanni de los Santos, 22 CR 267. He is not present. His presence was waived by his attorney, Joseph Krowski Jr. And also before the court, number 9, Commonwealth versus Sean Johnson, 22 CR 268. Attorney Krowski is standing in for Attorney Scapiccio. Mr. Johnson's presence was waived. And finally, before the court, Commonwealth versus Brian Walshe, number 10, 23 CR 91. Mr. Walsh's presence was waived. Attorney Larry Tipton is present. The Commonwealth is represented.
Hey, camera
by
person, can we move the camera?
Lisa Beatty. If the parties could please identify themselves for the record.
Good afternoon, Lisa Beatty for the Commonwealth, and there are various other assistant district attorneys representing the trial teams present.
All right.
Judge, good afternoon. Attorney Krowski again, as mentioned, standing in for Attorney Scapiccio on behalf of Mr. King, and standing in for Attorney Scapiccio on behalf of Mr. Johnson, and representing Mr. De Los Santos.
Thank you.
Larry Tipton for Mr. Walsh.
All right. And Mr. Cataldo?
Yes, good afternoon, Joseph Cataldo on behalf of Bianca Chancio.
Okay, we can hear you loud and clear, but we cannot see you.
I will, Madam Clerk, if I just log on, I'll come back in because it says my camera is working. And
No.
the video says
It's all right. Just so long as you're content, we're content.
All right, yes.
Okay. What is the current status?
Your Honor, Judge Casper issued an order on Friday which allows the Commonwealth to provide to the defendants who were in the cases that were called, in addition to some other designated defendants. It allows the order allows the Commonwealth to produce some grand jury materials to the defendants in those cases, provided that they are filed under seal. The order that was issued on Friday, we are also allowed to produce to the parties in the court as long as it's filed under seal, and an index, again, as long as it's filed under seal. So I have those materials present for the people who are here today, and logistics are making this a little bit complicated for people who aren't present. But we have some signed motions for protective orders and a draft order for this court. And assuming that the court endorses the draft order, then the attorneys can start signing the acknowledgement, which is at the bottom of the draft order, and the materials can be produced.
There's a draft order for this court to consider?
Yes. So I don't know, this is a signed one on Walsh. They're all identical at this point in time.
All right, let me take a look.
Yes. Yes, thank you.
Casper the Ghost finally issued an order on Friday. Praise be. He stopped ghosting. Well done, Grace Face. Sounds like there's a sleep machine in the background. Heather says it sounds like my husband's CPAP machine. The silence is deafening.
Okay, I understand the proposed order and the Commonwealth's motion for protective order.
I also have a copy of the index and the order of Judge Casper, if you want to review those, please.
Okay, I have seen that. This only covers certain grand jury material. It does not include the reference the TUI materials, right?
Oh?
The way that the process worked was that both items were considered grand jury materials because one was an exhibit in the grand jury. So they are both grand jury materials, as I understand it, based on, now I want to make sure that is the index also?
Yeah, the index is also referenced in, let me just see for a second, in your proposed motion, protective order.
So there is no separate TUI materials?
This has nothing to do with Proctor's other phone dump. This is just regarding federal.
So the entire universe of what the Commonwealth received from the feds or the federal court in connection with the Reed case is now going to be turned over.
No.
So that's my question.
Okay, I'm sorry, I didn't understand your question. I think, are you referring to the mention of TUI materials?
I am.
Okay, that was what was produced to the parties in Reed.
Okay.
So that is referred to as TUI materials for the purposes of what was produced to both the Commonwealth and the defense in Reed.
Right.
So this is a subset of those materials.
And the question is whether the obligation on the Commonwealth to review materials beyond what is contained in the order from Judge Casper is separately determined by the U.S. Attorney's Office regarding TUI materials. That is to say, the universe of confidential materials that we've been talking about for months.
Yes.
Okay? Is it all now going to be able to be reviewed by the Commonwealth and turned over to Defense Counsel, or only some subset covered by this order by Judge Casper?
We've already reviewed all the materials, and we had done that prior to the last court date before then.
Right.
We are only permitted to provide to Defense Counsel certain materials. These are the only materials that we sought permission after our review to provide. That is to say, the other materials we did not believe met our obligations under Rule 14.
So you reviewed all the confidential information, and the only materials that you felt needed to be turned over
Wow.
Were the two categories of information contained in Judge Casper's order. All the rest, you did not seek authorization either through the U.S. Attorney's Office pursuant to TUI or from Judge Casper to turn over.
That is correct.
Okay. All right. And, okay. I'll hear from the parties. The Defense Counsel, if they wish to address the court.
So I guess I'll start.
Hold on, Krowski's going to go berserk. Hold on. He's going to go berserk.
Attorney Krowski, on behalf of Mr. De Los Santos, my understanding of the order was that under the umbrella of grand jury, we are going to receive these materials, which would include all of the grand jury from the federal court, including any and all exhibits related to Trooper Proctor. It is my understanding, though, that there are
There may have been more than one exhibit, it seems
Right.
like you only get one exhibit.
There are materials outside of what actually was presented in federal court that we are also going to have access to, and that would be information from the cloud and the personal cell phone of Trooper Proctor, if I'm understanding that correctly.
So I want to make sure that I'm answering the question that's being asked, but separate from the motions regarding what was produced to both the defense and the Commonwealth pursuant to the 2A request. In King and Johnson et al., Judge Doolin had issued an order for Trooper Proctor's personal cell phone, the device, not the cloud, the device. And you modified that order. And we have been in the process of executing that order. And that is an entirely separate process from this.
Right. Right, that's what I was saying. I just wanted to be clear on the record that this is not on these cases and these defendants. This is not the end of the issue as it relates to discovery related to Trooper Proctor.
Right, but I want to be clear about what this does and doesn't do, right? The Commonwealth has done its review on all the confidential information that was obtained from the federal court, has made a determination that what needs to be produced is certain things, and as I understand it, the only things that are authorized to be turned over by Judge Casper are those things that the Commonwealth has already predetermined are the things that need to be turned over to defense counsel in this case because they constitute exculpatory evidence. But they have reviewed other things and made a determination that those other things do not have to be turned over, are not exculpatory in any manner in which exculpatory has been construed. And so it seems like the Commonwealth has discharged its obligation and has been authorized to discharge its obligation to review this information, the confidential information obtained from the feds, and has gotten the authorization to turn over the stuff they think needs to be turned over.
May I add two things?
Sure.
We also, because we want to be clear, as clear as we can be and as clear as the federal government will allow us to be, we sought permission to have the index, which I think is something that was discussed in hearings previously. So we also will have the index, which gives some idea of materials that we did not seek authorization to provide and do not have authorization to provide and are not providing. And then...
and that's the index of other materials.
Correct.
Okay? And that will, between the stuff that is authorized to be produced and will be produced, subject to a protective order, and the index, the defense will know all of the stuff that you reviewed.
And in addition,
is that right?
That's correct. That's the intention, is so that there's not a big mystery about what the other materials were. And in addition, and why those, as outlined in the U.S. Attorney's Office letter, why those other items are not Rule 14 material in these cases.
I'm sorry, the index indicates why they are not Rule 14?
It provides, the index itself doesn't provide that, but reading the index, I think, provides some information about why they're not Rule 14 material.
Okay.
And then finally, the order now contemplates, or orders, a return or destroy date of the other materials of October 31st.
I do have some concerns, obviously, in thinking about a reservation of rights on behalf of the defendants, because we're in this unique position here where the government is really the arbiter of what is or what is not Rule 14 exculpatory information. My concern is once we start getting into the actual discovery, it might become obvious to us that other information is out there that is not discovery. It's a very difficult thing from the position of a prosecutor to make a determination, not knowing the defendants and the defendant's theory of the case, what is or is not exculpatory. So I am concerned with these, quote, other materials being destroyed on October 31st, and I think there should be something put in place where we can at least have those documents set aside, not subject yet to any type of disclosure, but set aside for a potential future review.
So, Your Honor, this return or destroy provision, and I just want to make it clear that it is the intention of the district attorney's office to comply with the federal court order. We will be returning a set of documents and destroying all extra documents.
Wow.
So the defendants have had the ability to make TUI requests, to seek to intervene, and have not. We are confident that we have met our Rule 14 obligations, and I would tell the court, and the other assistant district attorneys who participated would tell the court if they were not confident. And again, I think the index will be helpful, and I'm able to provide that index today.
Remember how that worked out for Carrie Morrissey in New Mexico in the Alec Baldwin case when she decided what was to be turned over and what wasn't to be turned over, and the case was dismissed? Yeah, I remember that.
I think what I will do is, in an abundance of caution, and against my better judgment, because I really don't want to have another hearing in this, but I will schedule a time to see anybody who wants to be heard on the issue of the other list sometime next week, after you folks have seen it and have had a week with it, to consider whether you think there's anything that you need to bring to the prosecutor's attention about the things that might be on that other list. You obviously don't have the other list, so you shoot blind right now, but you'll have it today, and you'll be able to come to some sort of conclusion as to whether you think, given the information on that list, you have some reason to believe that it would contain exculpatory information, based on the chronologies in your case or whatever else it is.
Step back to get my phone.
Sure.
And just so the record's clear, Mr. Walsh joins in exactly what Attorney Krupp is.
Okay.
I am back here on October 30th. I don't know if that's a good date for the parties. I don't know.
Well, it's certainly a good date for me. I can accommodate you on the 30th, but it's a little bit close to the destroy or return date, I would think.
Yeah, need more time. I wish Rosemary Scapiccio was there.
Scapiccio, it's really the only date next week I can do. I'm out of state in federal court at the beginning of the week. At least it gets me in here to preserve.
I'm happy to see you on the 30th. How does the 30th seem? Okay, Mr. Cataldo?
If I can't do it, one of my colleagues would be able to stand in for me, so yes.
Okay.
We can do the 30th.
How does that look for you, Attorney Beatty? Okay.
And if we could just approach.
Okay. 30th at 2.
Am I issuing names for anyone, or waive your presence?
Could we
On behalf
have the position be issued?
Go ahead, Mr. Cataldo.
On behalf of Bianca Gentile, I'm after that her appearance be waived on the 30th.
All right, we will waive her appearance.
Thank you.
All defendants' presence waived?
Yes.
Yes.
Okay. All defendants' presence will be waived for the hearing on the 30th.
And Your Honor, there are a couple of other cases that we just need to finish the paperwork on. Can we do that administratively for the motion for the protective order and the court order?
Yeah, get them to us, and we'll make sure we get them approved. I've got 2 here. Let's see.
And then if we could have the orders that you've endorsed back just for now, so that I can have the attorneys acknowledge them, and then we will bring them back to the clerk.
Okay. Mr. Krowski, this has been signed by Ms. Capiccio? Are you signed it on her behalf?
With her authorization.
Okay.
And we'll do so for the King one as well.
Okay.
I wish Rosemary was there too.
All right, so I've signed 3 of them. I'm sure I'll get another 13 of them or something like that, to sign. Okay?
Your Honor, do you want a copy of the index? Or do you want to wait?
I'll wait to see if I need to see a copy of the index.
Thank you.
Okay?
If you want to just put those on my desk now, Steve.
And anybody who wants to file something in advance of the 30th, if you feel like you need to, you're welcome to. I'll look at it beforehand.
Thank you.
Okay?
So the matters are all continued to October 30th at 2 p.m. for status. Defendant's presence is waived, and we'll see you then.
Just a brief sidebar, please.
Sure.
Yes.
Wow. Oh, no, I can't listen to that sound machine. Hold on. I'm going to mute it until they come back. I'll explain. I'll break all this down to you after it ends. But if Rosemary would be going off right now. Rosemary Scapicchio would be like, no way, Your Honor. How dare you let the Commonwealth decide what they think is relevant and what they don't think is relevant? And Your Honor, they told us that they were going into federal court to have everything released in the 2E dump, not just what they thought was relevant. And that's exactly what the Commonwealth did. And they just said, we only went into federal court to ask for them to release what we think was relevant. We made our own determination about what was relevant. And it's only what it sounded like to me. She said, it's only the grand jury materials, some of them, but we gave you an index, like an index, like like at the end of a book, they have an index where you can look certain things up. And we think that when you read the index, you'll know that what we turned over was the only relevant stuff. Wow. It's not Brian Albert, you guys. It is not Brian Albert sitting in the back of the courtroom. Oh, that's horrible. We zoomed in. It's not him. And for those of you who watched the Alec Baldwin trial in New Mexico, Judge Mary Marlowe Summer was horrified when Carrie Marcy, who was also a special prosecutor, whose name is also Marcy, coincidentally, told the court, yes, there was some evidence that I didn't turn over, but I didn't think it was relevant. And Judge Mary Marlowe Summer dismissed Alec Baldwin's case right then and there. After this special prosecutor put herself on the stand, it was wild. We should watch that one day. That was insanity. Right, we're supposed to trust the index. But don't worry, it's okay. It's all right. It's okay. We're going to get them anyway, because they have a total phone extraction of Proctor's going back to 2013 that we went over earlier in the stream before the hearing started. And Greg Connor says who's an ADA with the Norfolk County DA's office, says there are things in there that he thinks he may have to turn over to independent law enforcement agencies in Proctor's phone dump. And so they're still talking, and there's a sound machine on. But the Judge Krupp seemed kind of surprised, right? When she said, oops. Oh, I thought it was frozen, but it's not. Everyone was just very still. Larry Tipton looked like a statue.
Next for the court number 13, Commonwealth versus Henry Samuels, 25
And that's it.
36. Mr. Samuels is present and represented by attorney Michael.
Let's see if we see anybody walking out. And they cut the feed. And that is it. To me, Judge Krupp sounded a little annoyed when I think that was Lisa Beatty. I'm asked that if you're here. Can you tell me if that was Lisa Beatty that was speaking? He sounded a little bit annoyed when she said, oh, yeah, we didn't ask for everything to be released from the federal protective order. We only asked for certain grand jury materials to be released from under seal. Only the grand jury stuff, not the entire 2E dump. She said the grand jury materials is just a subset of the 2E materials. And that she only asked the federal judge to review certain materials plus the index. And then in her own defense, she said, well, Your Honor, the defendants had an opportunity to do their own 2E request, and they also had an opportunity to intervene in the proceeding, but they just didn't. It was Lisa Beatty. Thank you. And then Krupp said, well, under an abundance of caution, I'm going to continue this to October 30th at 2 p.m. because on October 31st is the date that the Commonwealth is supposed to destroy or return all of these federal materials. Let me talk to you. Let me explain it to you in a very, very simple, in the most simple way that I can. If you were here with me covering the Karen Read trial before Karen Read's first persecution, before trial 1, I don't remember exactly when it was, but sometime before Karen Read's first trial, Josh Levy was the acting U.S. attorney for the state of Massachusetts. Josh Levy had a conversation with both sides, Adam Lally and the defense attorneys, via, I don't know, conference call or something. And Josh Levy said to both sides, in good conscience, I cannot allow the Karen Read trial to proceed, and therefore I am releasing something like over 3,000 pages from the federal investigation to both sides because in good conscience, I cannot allow Karen Read's case to go to trial. Contained within that, it's called TUHEY, T-O-U, I think it's T-U-O-H-E-Y or T-O-U-H-E-Y. TUHEY is a case under which there was established a procedure in which to obtain documents related to a federal investigation in which you are not a party, you have to go through this procedure. It's like just jumping through hoops. You have to go through a certain procedure before the feds are allowed to release information to you. T-O-U-H-Y, right. Can I turn it up? Can I turn myself up? You must be behind. And so, hang on. And so everything was turned over to both sides, and contained within those materials was not only the ARCA reports regarding the accident reconstruction for the accident that did not happen, the car accident that did not happen. But there was also, I guess, grand jury testimony, text messages of Proctor, all of the vile ones that had to do with the things that he called Karen Read, and the text messages, and also the group text messages between the McCabe's and Alberts and other people, and grand jury materials. And so the feds gave that to both sides under a federal protective order and said, as part of that order, that 60 days after the Karen Read trial was over, those materials that they turned over needed to be either destroyed or returned back to the feds. And Karen Read was acquitted. So those materials were turned over sometime in 2024. Karen Read's trial ended with her acquittal on June 18th of 2025. And so 30 days from there meant that those materials either had to be returned back to the feds or destroyed by, I think it was July 18th. And so I think it was the day before those materials were supposed to be destroyed. All of these other defense attorneys in these other cases in which Proctor was a lead investigator were advised, hey, there may be some stuff in here that's relevant to you because Proctor is a lead investigator on your cases too, but we got to destroy this stuff by tomorrow. And so all of these attorneys had to go into court, Rosemary Scapicchio, Joe Krowski, Joe Cataldo, Larry Tipton, and maybe one other, to try and prevent this stuff from being destroyed, saying this may be relevant to our cases. And so this was all assigned to Judge Krupp because Judge Frenier, who has been specially assigned to hear the Walshe case, had to recuse herself from this issue because she said that the attorney that the Commonwealth hired to represent them in federal court was a mentor of hers. And so that's why it's in front of Judge Krupp. Because of this issue, they've been fighting about this issue. The Commonwealth has been saying we can't release any of this stuff because there's a federal order and we can't violate the federal order, so we can't give it to you. This has been going on for months and months and months and months. Every time there's a hearing with Judge Krupp, the can keeps getting kicked down the road. And then finally, we thought we were seeing some progress. And the Commonwealth said, you know, Judge Casper is the federal judge. We're asking him to allow us to turn it over because Laura McLaughlin said in open court, she felt that some of that stuff was relevant, at least in the Walshe case and in the Myles King case. And the Turk case. Yep. And now we find out today that the judge has given them an order, but it's only with regard to some of the federal grand jury information because that's the only thing the Commonwealth asked the judge to rule on. And so now the new destruction date is October 31st, and the Commonwealth has given them some stuff today with an index saying why they think only that stuff is relevant. Krupp seemed surprised by that. Is it me? Was it just me? Laura McLaughlin. And so now he's scheduled another hearing, yet another hearing on October 31st. I'm sorry, on October 30th, because the destruction date, the date of self-destruction, is going to be October 31, which doesn't give anybody a whole lot of time because today, again, is the 20th. So now they've got 10 days to look at that index and see if there's anything else that was maybe relevant to them. And again, there was other stuff turned over in that 2E dump aside from Proctor's text messages. But they seem to think only the grand jury information is relevant. We're in the upside down, inside out, Narnia, Massachusetts of Norfolk County. That's just where we are. Land of the lost. Sometimes we have Chaka as our mascot because if you know about the land of the lost. But this is a completely separate issue than what happened with Proctor's phone dump, because right now, those materials are not under a federal protective order. They are not under any protective order at all, although the Commonwealth has said that they're going to move for one. But if you weren't here at the beginning of the show or Friday night, there has been a total extraction of Proctor's personal cell phone that was done in August of 2025, in which Proctor's attorneys told the court, the world, and everyone, you're not going to get a lot because he got a new phone in February 2024, and he's got everything to auto-delete within 30 days. So you're not going to get hardly anything. And this was spurred by Proctor's attorneys making a motion for clarification. And then Krupp said, yeah, I'm not limiting this to any dates. Go in there, get your extraction. And they did. And there's hundreds of thousands of messages going back to 2013 that the Commonwealth needs more time to go through. And that's totally separate from what was discussed today at this hearing. Turtle Boy just put up an article. So why don't we take a look at that? Because his sources tell him that there's a lot of racist stuff, apparently, in Proctor's phone. And maybe that's the reason why he decided to drop his appeal to try and get his job back with the Massachusetts State Police, because he was arguing that he was unfairly fired, unfairly targeted, and that the rules weren't being equally applied to him as other people who were in his same position. Okay, so here it is, hot off the press. Canton cover-up, part 536. Michael Proctor's union attorney drops appeal of state police termination after allegedly racist text messages about defendants and coworkers found in iCloud. Oh, this is a screenshot. Is this from when somebody went after Proctor to try and get some information from him and his attorney? This is his attorney. His attorney was not very nice. I don't remember if it was Aiden. I think it was. And then Aiden, he was like, stop following us. Stop following us. Michael Proctor's union attorney, Daniel Moynihan, there he is on the right side of your screen, confirmed today that he has dropped Proctor's appeal to get his job back after being terminated by the Massachusetts State Police prior to the start of Karen Reed's retrial in the murder of John O'Keefe. In August, Proctor was subjected to 2 full days of testimony in front of the Civil Service Commission, in which video footage of his testimony in Karen Reed's first trial was replayed. He was scheduled to go in front of the commission later this month, but will no longer be doing so since he has given up his fight to get his job back. Right, it was supposed to be tomorrow, Wednesday, and Thursday, full days. And I remember, so they've already had 2 days of hearings, and all of his testimony was played back, and all of his cringy text messages were played again, and his family was in the room, and it was likely, falls under the category of you better want what you wish for. What isn't being reported until now, Aidan Carney goes on to say, is why Proctor is giving up. Proctor has shown us time and time again that he's both arrogant and shameless. After all, he wanted to stay in a job where he wasn't wanted and where he knew that anywhere he went, he would be followed by the permanent stain that Karen Read has left on his reputation. So why is he suddenly throwing in the towel? At the Civil Service Commission hearing in August, Attorney Moynihan said that Proctor changed phones in February of 2024, did not preserve his old phone, and turned on a feature in his new phone that auto-deletes his text messages after 30 days. There's just one problem with this, though. He can't delete the cloud. And on Friday, the Commonwealth filed a motion in the Brian Walshe case, which said that the extraction of his cloud data has revealed hundreds of thousands of items dating back to 2013. The motion did not state what any of these messages said. However, it did say that after reviewing the extraction, the Commonwealth has identified data in Proctor's phone that it reasonably believes to be discoverable in the King matter. And there's the part of the filing that we just went over a little bit earlier. And the footnote. Myles King was arrested and charged with the murder of Marquise Simmons in Milton in July of 2021. Proctor was the lead investigator in that case and conducted a thorough investigation in which he did all sorts of things that he didn't do in the investigation of John O'Keefe's murder, including speaking with witnesses and asking to review surveillance videos at local businesses and homes in order to build a case against King. King glorifies guns and violence in his rap music and was previously charged after being in a stolen car outside of the murder victim's home with a loaded gun 2 years prior to the killing. According to our sources, the reason that the Commonwealth specifically said that data found in Proctor's phone would be discoverable in the King case and not the Walshe case is because Proctor has a plethora of text messages using racial slurs in reference to people he has arrested. Myles King is black. Additionally, sources are reporting that Proctor has text messages in his phone, which he uses racist language in reference to fellow state troopers in order to degrade them. Other messages are reportedly homophobic in nature. Attorney Moynihan became aware of these messages after the motion was filed by the Commonwealth on Friday. He cut Proctor off yesterday because the messages are reportedly indefensible. Sources from Canton who are close with friends of the Proctor family tell Turtleboy Daily News that Michael Proctor freaked out when he found out his attorney was quitting and has been telling people that his wife Elizabeth will leave him if he loses his job. Elizabeth Proctor's goal in life, and remember, these are Aidan Carney's words that I have not read to you yet. This is a cold read, or have not read yet, even myself. Elizabeth Proctor's goal in life was to be married to a cop, which is why she has been his biggest and most aggressively outspoken defender. If Proctor loses his job, she will lose her entire identity. Her father was an FBI agent. Her brother is a detective for the Belmont Police Department. She could stomach the fact that Proctor texted his friends and said he was looking for naked pictures of Karen Read on her phone. She told David Bienick as much during an interview between the two trials. And the quote that he pulled is, "I understand the need he had to vent to friends, whether it was appropriate or not. She could understand and make peace with the fact that her husband was a filthy misogynist known to millions of people around the world as a pig and a disgrace to law enforcement, but only because she still got to be the wife of a cop. However, the prospect of being married to a man who isn't a police officer is a shame and a burden that could be too much for her to carry." Liz Proctor went so far as to contact the employers of multiple victims. To contact the employers of multiple civilians in May of 2023, who had shared their opinions on Facebook that her husband deserved to be fired for his involvement in the cover-up of John O'Keefe's murders. Liz Proctor called these people's employers in an attempt to have them fired for exercising their First Amendment rights and to intimidate them into silence. There's a picture of the happy couple. I guess. She looks pregnant, so maybe that was in earlier days, happier times. And there's a post that she laughed at. Somebody posted something under Boston 25 News, April 12th, that says the visibility was poor and she was likely buzzed. She may have clipped him with a bumper, but his injuries indicate he was beaten. Big difference between a hit and run and a beating. Seems like not all the facts are being told. And there was one laughing emoji underneath that Facebook post, and that was Elizabeth Proctor. Turtle Boy goes on to say she fought hard and didn't want to give up the dream, but it's officially over at this point. Mychal Proctor will never be police officer again, and she will never be the wife of a cop as long as she remains married to Proctor. What's unknown is who was on the receiving end of Proctor's text messages, exactly what was said in the messages, and who the people are he was saying racist and homophobic things about. Either way, if these reports are true, then Proctor has officially become the new Mark Fuhrman. And if and when the King case goes to trial, Proctor will be cross-examined by Rosemary Scapicchio, who has a long and documented history as a defense attorney of exposing racism in police investigations. His problems have only just begun. Maybe we need that on the playlist. We've only just begun.
There's Mychal Proctor.
And here's a link to Turtle Boy's YouTube video where he interviewed Mychal Proctor's attorney. That was a screenshot from his video. Let's watch that again. I think this was after the last Civil Service Commission hearing, I think. Oh, no, I'm sorry. This was after the Myles King hearing. This must have been the one where Proctor was in court and he was supposed to testify that day, but the plug was pulled on that hearing. So, and then we have a filing to look at from that. So let's take a look at this. Shout out to Turtle Boy.
There's Mychal Proctor on his way out of court. This should be interesting. Oh boy. Okay. As you can see, he appears to be fatter than before. That should be interesting.
There is a witness in a homicide case. That's it. Yeah. Not a defendant here. He's just a witness in a homicide case. Subpoenaed here by defense attorney. Focus on the homicide case. Focus on the victim's family.
Can you say anything about how likely that is?
Not gonna predict. I don't make predictions. We have a case. That's all I'm going to say.
Mr. Proctor, would you like to say anything about the accused family?
Any comment about your wife calling people's jobs to get them in trouble?
Thank you.
Can you fix the delay in search warrant?
Have a nice day. Have a nice day, everybody.
Any comment? Yeah, I didn't think so. Look on your face. That's what's there.
Have a nice day.
Okay.
How's the diet going? Good? No? Mr. Proctor, have you obtained employment since being terminated by the state police? Hello, Mr. Attorney.
Hello, Mr. Media.
Maybe you can answer. Has Mr. Proctor obtained employment since being terminated by the state police?
He's going to go to communication school.
Ah, that's good. Never too late.
Never too late to go to communications school.
Okay. Do you know why Brian Tully was here today? Is he involved in this case?
Who asked the DA?
Where can I find him?
I don't know. They're in their office. They got an office.
Michael Morrissey's like a hermit. No one can find him.
They got an office in the building.
I know. I've never seen Michael Morrissey in the flesh. I don't think anyone has. He didn't come to a single day of the Karen Reed hearing trial, even though it's like kind of like a high-profile trial. It was just weird not seeing the DA there. But yeah.
Are we all set here?
Yeah, I'm just filming. Is that okay?
Yeah.
No, I'm not starting anything.
Okay. What are you filming for? What do you want to know?
Well, you heard my questions.
What, where's Mr. Tully?
Well, that, and most people want to know, like, what's Mr. Proctor doing for work these days?
That's nobody's business.
I know, but I'm just asking. It's not a crime to ask, right?
The answer is it's nobody's business.
Okay.
Mr. Tully, go ask the DA's office. I don't know if he's here.
Have you seen the DA?
Who, Morrissey?
Yeah, Morrissey.
No, I
no
haven't
one
seen
has.
him in years.
You'll
Seen him in years.
Yeah, welcome to the club.
Either.
You know?
But we don't have that answer, so why don't we just let this go?
Let what go?
Well, you're following him.
Oh.
To his car.
Well, I'm just filming.
Yeah.
Okay. I mean, I can leave if you want. I just wanted.
Yeah.
Okay.
Have a nice day.
All right. We'll let him go.
Did he let him go? Well, let's get to the chat. He did call him Mr. Media, so I guess he thinks he's a journalist. Living that GP life lifestyle, says Proctor. He had it coming. He had it coming. He only had himself to blame. Happy days, cupcakes. Love you too. It's my favorite song from my favorite musical, Chicago. If you know, you know. Nina says, I missed how they got his phone in the first place. It's not from the FBI dump, right? No, it was from a Judge Krupp ordered it. Judge Krupp ordered Proctor's attorney to hand over Proctor's cell phone to the Commonwealth in August of 2025. And they did. And they did a total extraction, and then they returned it, and they got hundreds of thousands of messages. And so this is totally separate from the FBI dump. Thank you, Nina, for tuning in from Europe. Charlie says, words cannot express how much I appreciate you. I'm hoping the Commonwealth and judges don't attempt to prevent disclosure of this mandatory discovery. Well, I think that's what Krupp was signing at the end there. He was signing a couple of protective orders to keep them private for now, in each case. And so he had a bunch of them to sign. And it sounds to me like that's what he was doing, was signing protective orders. But you know what happens. Sunlight is the best disinfectant, and these things always come to light. Thank you, Susan, for gifting 5 memberships. You are so generous. And if you believe Aiden Carney's sources, many of these text messages might be racist and or homophobic and or who knows what else. Who knows what they're going to find in the photographs? They haven't even gotten through all the photographs yet. Kubert says, hey, Attorney Mel, I was in the ladies' room at Whole Foods and someone in there had you on, so I scooted out to the car to listen. I didn't want to run into a local. That's funny. Thank you, Charlie Lynn, for gifting 5 memberships. You're amazing. Welcome to the new 10, 20, lots of new members today. West Virginia Country Guy says, catching up in the video, but I would bet some audio files are Proctor wiretapping people, maybe even Aiden, Karen Reed, etc. More Cosgrove dipping. Oh, that's interesting. That's an interesting thought. You never know. You never know. Remember, they sent Proctor to put a GPS on Brian Walshe's Volvo. And I think it was like in his garage at the time. I have to go back and look at those documents again, but interesting. Did he ever put a GPS on anybody else's car? I don't know. Thanks for your super chat. Bailey says, remember when Krowski went on Vinnie Politan to say how honest Proctor was? I do. Yeah. One of the reasons I started turning down Court TV, because I didn't feel like fighting with Joe Krowski. It wasn't the way that I wanted to spend my evening, fighting with Joe Krowski. Alicia says, for a matcha latte, Melanie, wait, that's probably not enough money. I was thinking that in Utah, cost not NYC. I'll double my extra $10. You're sweet. Thanks, honey. Expert Architect 6, Carrie Morrissey completely folded up shop. And oh, you sent an email? I'm not surprised. I'm not surprised. Thank you. Catherine Smith, thanks for 20, says, oof, Proctor and wife should look into being relocated. Canada, perhaps? Seems like he's about to make a lot of people upset. Pass the popcorn. I mean, it's all very interesting timing. Follow the money. Thanks, Bridget, for your super sticker. And then Bridget says, this is better than a movie any day. Thank you for your super chat. Christy, RN, says, question 1, the 2013 to 2025 Michael Proctor extraction isn't in today's matter, right? Right. Question 2, regarding today, how can the defense ask for relief if they didn't get the info until today? Well, that's why they're coming back in 10 days. So he put it over for 10 days. to give them time to take a look at it. Thanks, Amanda, for becoming a new member. Krowski was Colin Albert's attorney. You are correct. You are correct. Wow. Wow. Hang on. Here's an article that just broke this morning. In the Boston Globe regarding Brian Walshe attorneys, and says they may be calling Proctor to the stand. So let's take a look at this. Thank you, Tiffany. News just keeps breaking and breaking and breaking. KBD says, I think Krowski didn't think all this was possible until he saw it with his own eyes. So this story broke this morning at 10:28 a.m. Brian Walshe attorneys could call former state police investigator MICHAEL Proctor at trial. Records show. Oh, and there's Brian Walshe a long, long time ago. Before LC, the jailhouse barber, got to him. And it goes on to say, lawyers for Brian Walshe, the man who allegedly killed and dismembered his wife in Cohasset, may call former state police investigator MICHAEL Proctor, who was fired over his conduct in the Karen Reed case, as a witness when Walshe stands trial. Records show the possibility that Proctor, who served as lead investigator in both high-profile cases, may be called as a Walshe defense witness, was disclosed Friday in a joint pretrial memorandum, which reiterates that prosecutors do not intend to call the ex-trooper. The Commonwealth is not calling former trooper MICHAEL Proctor, but requests that his name be announced as he was present for the recorded interviews of Walshe, and jurors will hear his name, prosecutors said in the memorandum, later crossing out most of the sentence and noting the request was moot in light of the defendant's witness list, which includes Proctor's name. I haven't seen that memorandum yet. I don't know if it was scanned by the time I did my show on Friday night. Proctor was fired after he was forced during Reed's first murder trial to read crude and misogynistic texts he sent about her. That trial ended in a hung jury, and Reed was acquitted of killing her boyfriend in June at her retrial, at which Proctor did not appear. In a separate filing on Friday, prosecutors said they're still working to cull data from Proctor's phone for Walsh's lawyers to review. On Thursday, prosecutors said they filed a notice of discoverable information on the phone. The Commonwealth is attempting to produce information from that review, which is not specific to this case, from texts and chats, video and audio files, but requires additional time to complete its review of other files on the phone extraction, including emails and photographs, prosecutors said in the memorandum. Well, we covered it on Friday. The Boston Globe is just picking it up today. And at least they picked it up. And just to clarify, it was not a motion that the Commonwealth filed. It was a notice of discoverable information from former MSP troopers' personal phones. So it was not a motion. The article says they said they're also conducting a review of the phones for Walshe case-specific material and anticipate completing the case-specific review no later than October 27th of 2025. Walshe, 50, has pleaded not guilty to murder, unlawful disinterring of a body, and lying to investigators in the January 2023 death of Anna Walshe, age 39. He's currently being held without bail at Bridgewater State Hospital, where he's being evaluated for his competency to stand trial after a jailhouse attack last month briefly sent him to the hospital for treatment. We covered that hearing too. Should Walshe be deemed competent, his trial is scheduled to begin November 18th in Norfolk Superior Court, according to legal filings. Authorities allege that Walshe murdered his wife in the pre-dawn hours of January 1, 2023, and then dismembered her body, leaving her remains and other evidence in dumpsters at various locations. Among those sites, court papers said, was a dumpster outside Walsh's mother's apartment in Swampscott, where authorities found clothing that he said his wife was wearing when she abruptly left their home early on January 1st. The dumpster also contained Anna Walsh's, vaccination card, towels with red-brown stains, a hatchet, and a hacksaw, the joint memorandum said. Prosecutors have also said that Walsh made a number of chilling Google searches on his son's tablet soon after allegedly killing his wife. They indicated all of those things that I'm not allowed to say on YouTube because they'll demonetize me, like 10 ways to dispose of a body if you really need to, how to stop it from decomposing, and how long before it starts to smell. They were made between 4:55 a.m. and 5:47 a.m. on New Year's Day, prosecutors said. What effect do you think this latest Proctor phone dump is going to have on these cases? I mean, Myles King, who's accused of a 2021 murder, was being held for so long that they finally let him out on bail. And he did violate his bail conditions, we found out, by going out of his house without telling anybody. But then it turned out that he moved and the records were screwed up, so he wasn't charged with a violation of his bail conditions and he didn't get thrown back in. I mean, could a jury find that Michael Proctor was so biased that the investigation couldn't have been on the up and up? And remember, it's going to be a Norfolk County jury. They've been through the Karen Reed 2 trials. They know about Proctor. They know about his bias. They know about, John O'Keefe was not hit by a car and a car did not hit John O'Keefe. So I think Brian Walshe, even though he's moving for a change of venue, I think he would do better in Norfolk County, don't you? Based on all the shenanigans that went on with Karen Reed, in my opinion. Let's take a look at this filing on Myles King that just landed in my inbox that we did not have a chance to go over because it kind of flew under the radar. But this has to do with the hearing that was being held where LALLY was on the stand. So let's take a look and see what the Commonwealth has to say about that. Because the shenanigans continue. This is docket number 169 in Myles King's case. And this was filed on October 9th. It is the Commonwealth's response to defendants' motion for discovery relating to witnesses at the motion to dismiss hearing. The Commonwealth hereby responds to the defendant Myles King's motion for discovery relating to witnesses at the motion to dismiss hearing. First, the defendant's motion is premature. The defendant premises his motion on a continued evidentiary hearing on his motion to dismiss and any supplemental motions to dismiss, but the court has not ordered one. The court scheduled a non-evidentiary hearing for October 31st, 2025 on this matter. So when we heard Judge Krupp earlier saying that he wanted to put it on the 31st because he already had King coming back, that wouldn't make sense because that was the destruction date. And if you didn't watch that with me, it was wild. It was LALLY was on the stand. It was in Myles King's motion to dismiss, and LALLY was being questioned about why he did not turn over basic search warrants that were within the Commonwealth's possession since the day of Myles King's arrest all the way back in 2021. Notwithstanding, the Norfolk DA's office is aware of its duties of inquiry and production under Rule 14. A prosecutor's core duty is to administer justice fairly. Under both the federal and the Massachusetts constitutions, due process requires that the prosecutor disclose evidence favorable to the defendant where the evidence relates to either guilt or punishment, and that's Brady versus Maryland, U.S. Supreme Court case from 1963. This duty is based on federal and state guarantees of due process and the Massachusetts Rules of Criminal Procedure, which, citing Brady, which stands for suppression by the prosecution of evidence favorable to the accused upon request, violates due process where the evidence is material either to guilt or punishment, irrespective of the good faith or bad faith of the prosecution. And citing also matter of grand jury investigations. In Massachusetts, when we speak of a prosecutor's Brady obligations, we mean not only the constitutional obligation to disclose exculpatory information, but also the broad obligation under our rules to disclose any facts that would tend to exculpate the defendant or tend to diminish his or her culpability. The defendant's discovery motion, however, seeks information and materials beyond Rule 14. When are they going to continue that hearing? The defendant's requests 1 to 5 for communication by prosecution team and or other Norfolk DA's office members are outside the scope of Rule 14, overbroad and unduly burdensome. All disclosure obligations impose a duty to make reasonable inquiry under Rule 14. Reasonableness is the only limitation on the prosecutor's duty of inquiry. The duty of inquiry necessarily requires asking members of the prosecution team whether they have provided all discovery. Citing Graham, which was one of Judge Cannoni's most favorite cases, that says reasonableness demands at the very least that prosecutors ask other members of the prosecution team whether exculpatory information exists, particularly any information specifically requested by defense counsel or required to be disclosed under Rule 14. And Commonwealth v. Diaz, where defense counsel had requested all cell phone data, the scope of reasonable inquiry for the prosecutor, informed by the defense request for the call log data, extended to inquiring of the detectives whether that information was accessible to the government. Here, on May 28th of 2025, the defendant filed a motion to dismiss due to the production of late discovery. In its response, the Commonwealth agreed that the prosecutor previously assigned to this case, that was LALLY, failed to timely disclose mandatory discovery in violation of Rule 14. Prosecutor's duty to disclose materials favorable to the defense necessarily carries with it a corresponding duty to investigate accusations of misconduct by any member of the prosecution team. Oh. Are they investigating accusations of misconduct regarding LALLY? Maybe not only in Myles King, but maybe also in Karen Reed. Inverted video from the Sally Port that was never turned over until after trial number 1. Video of the Canton PD parking lot that wasn't turned over until after trial number 1. Was Laura McLaughlin involved in that too? Consistent with Graham and McFarland, following the defendant's examination of ADA Adam LALLY on July 21, 2025, the Commonwealth reasonably inquired and produced ADA LALLY's emails with the Milton Police Department and MSP, including but not limited to Milton Deputy Chief Michael Collins, State Police Lieutenant Brian Tully, and former State Trooper MICHAEL Proctor. There it is. They got the emails. So that answers my question. LALLY was on the stand on July 21st of 2025. Krupp did not order the extraction of Proctor's phone in the Walshe case until August, about a little over a month later, maybe 5 weeks later. And as a result of Adam LALLY's skewering on the Scapiccio barbecue on July 21st, the ADA went and got all of LALLY's emails with Tully and Proctor and turned them over, in addition to Deputy Chief Michael Collins. The emails. The defendant's request for the Commonwealth to inquire and search through other prosecution team and Norfolk DA's office members' emails, text messages, notes, memoranda, other communications, private email, or text by or between witnesses exceeds the prosecutor's duty of reasonable inquiry. C. McFarland. Duty of inquiry is not unlimited. I don't have in front of me what they're asking for, but I'm thinking it's Michael Morrissey's emails, because a lot of those were released publicly in a FOIA request, and we went over them. The defendant's argument that a search of these forms communication will result in mandatory discovery under Rule 14 is without any factual or legal support. In addition, contrary to the defendant's arguments, the revised Rule 14.2 still does not entitle the defendant to a carte blanche review of the prosecution team's members' thoughts and strategy. The defendant also seeks work product in request number 2, for example, where he requests communications or materials memorializing any communications relating to the subject matter of the following witness's testimony. Rule 14, parentheses, defendant not authorized to discover portions of records, reports, correspondence, memoranda, or internal documents of the adverse party, which are only the legal research, opinions, theories, or conclusions of the adverse party or its attorney and legal staff. The Commonwealth is aware that work product does not include any items or information that the prosecutor is obligated to disclose as items or information favorable to the defense, and produced ADA LALLY's emails described above. Also, with respect to request number 4, the Commonwealth timely produced Commonwealth's notification of statements and law enforcement inquiry and Commonwealth's disclosure of witness statements. However, it would be unduly burdensome and maybe really damaging, those are my words, to review all mediums of communication of the prosecution team and other members of the Norfolk DA's office, absent a showing of relevance to the issues raised by the defendant in his motion to dismiss. Well, I think maybe Proctor's total phone extraction might give them some more ammunition to get some more of this stuff. I don't know. What say you? With respect to request number 6, Commonwealth has previously provided all the files on the USB drive referred to by Proctor given to ADA LALLY regarding the search warrants. With respect to request number 7 for all training materials from the Norfolk County DA's office from July 10th until the present, July 10th of 2021 until the present, the Commonwealth produces the following to the best of its knowledge after reasonable inquiry. If you didn't see that hearing where LALLY was on the stand, maybe we should replay some of that. Because Rosemary Scapiccio was like, I'm sorry, were you ever trained when you joined the DA's office? Because remember, that's LALLY's first and only job as an attorney is, I believe, with the Norfolk County DA's office, right? Like that's where he started his career. That's where he's been. I don't think he's ever had another job. And so Rosemary Scapiccio started asking him if he could, if he was trained and if he had any training materials and what did they teach you? If anybody could, I don't have it at the ready, but if anybody can email me like a clean copy of that hearing, maybe Trial Channel has it, then I can pull it up. Because if I take the time to look for it, it's going to take me a long time. That'd be great. Thanks. So here the Commonwealth is producing the CJIS training materials. It's a PowerPoint, 9-page PowerPoint. Norfolk DA's office, CJIS user information for staff. A Corey training PowerPoint, that's 39 pages. Corey individual agreement of non-disclosure, 1 page. And Norfolk DA's office, DCJIS, CJIS policy dated January 30th of 2020. Okay, well, I don't know when the rest of this stuff. Oh, from 2021 until the present. Well, they turned over something from 2020. They even went above and beyond their obligation. Could you imagine? Authentication, PowerPoint, 19 pages, domestic violence trials. dated September 30th, 2021, 30 pages. Norfolk DA's office deconstructing a motor vehicle homicide investigation PowerPoint dated April 29th of 2025. That's interesting, isn't it? It's a 94-page PowerPoint about how to deconstruct a motor vehicle homicide investigation. And that dropped right in the middle of Karen Reed's second trial. They decided that's when they were going to train their DA's office on how to do that. It's 94 pages. Maybe Corey Hopkins can get it. Oh, thank you. Whoever just sent that to me. I appreciate you so much. Public records PowerPoint, district court mental health training PowerPoint, victim witness advocates training printout dated September 28th, 2021. Victim witness advocate training printout September 26th, 2024. That was after Karen Reed's first trial. That'll be interesting to see what they changed. It's 7 pages longer than the one they had in 2021. District court training materials, advocate training checklist, administrative subpoenas training, dated April 2024. Making Norfolk County a safer place to live. That'll be an interesting one to get a hold of. 2025 training agenda, 1 page. Asset forfeiture training. Oh, Corey Hopkins was digging into this too, the asset forfeiture, about whether they used any asset forfeiture funds to pay for the experts in the Karen Reed trial. That's dated April 29th, 2025, and it's 14 pages long. Somebody send the bat signal out to Corey Hopkins. NAC multidisciplinary team orientation flyer dated May 29th, 2025. School resource officer training materials. Search warrants PowerPoint, June 2023. School resource officer memorandum of understanding from 2022. Role of the Office of the Norfolk District Attorney memorandum of understanding. NDAO diversion programs as of April 2018. 51A mandated reporter training. And a list of many other things that I do not read I don't need to read every single one of them to you. But I will scroll through here so that you can look at them closer later if you choose to. But here they are saying, we're turning over all of the stuff. We're giving you everything. We're giving you everything except for the stuff we don't want to give you. Here's all the training materials, though. And notice how a lot of this is dated after Karen Reed's trial, the first trial, which ended in a hung jury in 2024. No, this is not the index. This is something totally different. This is something totally different. This is a filing in the King case, something totally different. Rule 14, yeah, so it's important here. So yeah, the Rule 14 training in 2025 is because Rule 14 was revised in 2025. And if I recall correctly, well, I remember exactly that Beverly Cannoni was like the chairman of that committee to revamp Rule 2025. And I think it took effect, on March 1st of 2025, I think. So that's why they would have had to have done new training, because they changed the rule to make it broader after Karen Reed's first trial. With respect to request 8, oh, and there's some stuff here about the Norfolk DA's office law enforcement notification policy dated May 20th, 2025, and Superior Court law enforcement witness checklist dated May 20th, 2025. Request number 8 wanted training materials of the MSP, criminal investigations from July 10th, 2021 to the present. And request 11 for MSP policy and process on criminal investigations and homicide investigations from July 10th, 2021 until present. The Commonwealth produces the following to the best of its knowledge after reasonable inquiry. And there are a whole bunch of general orders here with dates ranging from January 2021 There's 10 of them through December 6, 2023. With respect to request 9 for training manuals from the Milton Police Criminal Investigations from July 10th, 2021. Until the present, the Commonwealth has reasonably inquired, and to the best of its knowledge, the Milton Police Department does not possess the requested materials. So Milton does not have any training manuals, apparently, for criminal investigations from 2021 till now. And then they go on to say that the defendant's specific requests 10 and 12 are outside the scope of Rule 14. Without grounds or legal support, the defendant requests performance reviews and disciplinary actions involving ADA LALLY. Oh, they asked for it, but they're not going to get it because the Commonwealth doesn't want to give it to them because they say it's outside the scope. They could have just said none exists, but they didn't. They said it's outside the scope. And then they say the defendant also seeks information and materials regarding counsel retained in response to the defendant's motion to dismiss, but does not explain how it's relevant to the issues raised. Where the Commonwealth has conceded untimely disclosure of mandatory discovery, the sole unresolved issue is sanctions, if any, for noncompliance with Rule 14. Beyond the jointly requested and court-ordered continuance of the defendant's trial and reduction in his bail. The defendant makes no argument how ADA LALLY's personnel file and retention of counsel would be favorable to him regarding his motion to dismiss. Right. He showed up to that hearing with an attorney. XOXO. Michael McGee, ADA Michael McGee. I don't think I've ever heard Michael McGee's name before, but he's the one who signed off on this in the Myles King case on October 9th, 2025. Interesting. Let's go back and watch the hearing that generated the notice for discovery that they're talking about there. And shout out to the trial channel for doing the Lord's work. And chopping this so that we can watch it. You guys want to watch it? I think there's some breaks in here. Wait a second. Let me just see. It says it's an hour and a half long, but I mean, we're here. This is the Zoom feed. Was there another feed? I think it's the Zoom feed. Let's take a look. We were so excited for Lally to come back on the hot seat, and then it never happened. Everyone go give a trial channel a like and a sub. I will mention them underneath in the show notes so that you can find it more easily. And this was July 21st, 2025. And there it is, the trial channel. And it was in front of Judge Krupp.
Certain materials bait stamped in the notice of discovery 28. It's a little difficult for me to figure out whether this is entirely new based on the chart or whether it's some similar document or similar information, but in a different form or what have you. But take any line, you know, I mean, take Bates number 114 towards the bottom of page 13.
I'm going to fast forward a bit until Lally gets on the stand. Here we go. I seem to recall that there was there another feed that had like where we could see Lally on the stand. If anybody has that feed, can you send it? It might be Boston 25 had it or Boston 10. Fanbase at mlittlelaw.com. But we'll watch this until we can.
What did you do before you worked?
I could be conflating it. Okay, here we go. This
The
is
objection.
I'm joining the objection, Your Honor.
Do we want a?
okay. So Adam Lally took the stand, and this is going to be Rosemary Scapicchio questioning him. And this is in the Myles King motion to dismiss hearing that was held July 21st, 2025. So when people come into the chat and are like, what is this? What is this? This is old. Is this new? You can just direct them to the scrolly thing on the bottom of the screen. Okay. All right. Here we go. That's Jim's head bobbing up and down. I know. How sad that I know that. Okay, hold on.
ADA Hickman present for this questioning.
I do not judge it. She's going to be a witness as to what she.
Oh no, how do I get rid of this?
How
do I get rid of this?
I don't think she should listen to what Lally says he had in the file before she testifies.
I don't want the comments on there. I don't want them on there. How do I get rid of that?
That's no dispersion on ADA Hickman at all, Judge.
I understand. I'm going to overrule the request for sequestration of ADA Hickman. She's counsel of record now and an officer of the court, and I'm confident that we do not need to extend the sequestration order to her. Your objection's preserved, Attorney Costa, to the extent you join in the objection.
I'm joining the objection, Your Honor.
And you have a standing joining of objections, if you wish, all defense counsel.
Thank you.
Okay, but others should be sequestered.
The witnesses are sequestered. Thank you. Now.
This is Lally being sworn in.
Tell me so the evidence you give the court in the case down here and the truth, the whole truth, and nothing but the truth, so help you God. Yes, thank you.
Good morning, Mr. Lally. In a loud, clear voice, could you please state your name, spelling your first and last name for the record?
Sure. Adam Lally, ADAM, last name LALLY.
And what do you do for a living, Mr. Lally?
Assistant District Attorney with the Norfolk County District Attorney's Office.
And how long have you worked for the Norfolk County District Attorney's Office?
Since 2005.
20 years?
Yes, almost.
What did you do before you worked for the Norfolk County District Attorney's Office?
Started with the District Attorney's Office straight out of law school. Worked a couple warehouse jobs, things like that during.
Sorry,
I was right about that. That's the only job he's ever had is with the Norfolk DA's office. That's his only lawyer job ever.
I worked a few warehouse jobs, things like that during law school. Went to school at night.
Okay. And what school did you go to?
Suffolk.
Suffolk Law?
Yes.
And undergrad?
Undergrad, I went to the University of Southern California.
Okay. And what was your well, at some point, how long were you in the office before you got assigned to the homicide squad? Oh, homicide unit, I'm sorry.
I'm not sure that it's an assignment to the homicide unit. I would say the first homicide that I had outside of the realm of motor vehicle homicide was probably 2015, somewhere in there.
Okay. And let me back up a little. What type of training did the Norfolk County District Attorney's Office offer you in order for you to be able to comply with Rule 14 discovery?
Objection.
Sustained.
So,
see? Judge sustained that objection, but then Rosemary Scapicchio followed up and demanded it anyway. And they just got all those discovery materials that we just looked through the list of.
when you started at the Norfolk County District Attorney's Office, you started in district court?
Yes.
Okay. And how many district court cases would you say you tried?
I have no idea. A lot.
More than 100?
Probably.
Okay. And in all of those cases, were you able to comply with Rule 14 discovery and turn over the discovery that was required under Rule 14?
Objection.
Sustained.
Let me ask you this. The hundreds of cases that you tried in district court, was there ever any allegation that you didn't turn over information?
Objection.
Overruled.
No.
Okay. And then at some point you moved to Superior Court. When was that?
Began working on Superior Court cases probably in 2006, full-time assigned to Superior Court in 2012.
Okay. When you say full-time assigned to Superior Court, what does that mean?
So what that means is during the interim period from 2006 to 2012, I had cases in Superior Court, but I was primarily assigned to the District Court.
So you were trying cases in the Superior Court, but you were still trying cases in the District Court?
Correct. Actually, I still do that to this day.
Lally and Proctor have been working together for the entirety of Lally's career and the entirety of Proctor's career. I think we looked it up. I think someone looked it up for me, and you told me that Proctor became, he was an MSP officer since 2012. Was it 2012 or 2013? And was he assigned to Norfolk DA's office since that time, since 2012 or 2013? So they have worked together for 12 years until, you know, the dishonorable discharge, that is. So think about that. They've had a working relationship for that long, because there's a weird thing in Massachusetts where these state troopers are assigned to a specific DA's office. You see? Doesn't work like that everywhere in other states. So Proctor's in Boston, Lally around for 12 years, says Magnolia Gypsy. Yep. Oh, the phone thing is going to be good.
You still try cases in the District Court as well?
I do.
Okay. But you said at sometime in 2012, you were assigned to the Superior Court. Does that mean you came here every day?
Correct.
Okay. And what type of cases were you assigned in 2012 when you became a Superior Court DA?
Variety, pretty much ran the whole gamut. Narcotics cases, sexual assault cases, child abuse cases, breaking and entering, armed robbery, whatever I was assigned, that's what I did.
How long after you got to the DA's office did you start trying what they call light felonies?
I don't understand the line of inquiry. Everybody who is in the DA's office is responsible for complying with Rule 14 and is expected to know the confines of Rule 14 and to comply with it. So the backstory here is not particularly useful. What I want to know is what ADA Lally did in this instance.
Understood, Judge.
Oh, sorry. Okay.
In any event, when were you assigned to the Myles King case? And Brianna Gardner, I'm sorry.
Probably within a day or two.
A day or two of what?
Frozen.
Of the shooting and the murder occurring.
Okay. And how do you get assigned in the district attorney's office? Do they email you? Do they call you? How do they do that?
Objection. Overruled.
I received a call from the first assistant.
And who would that have been at the time?
At the time, that would have been ADA Lynn Beelan.
Okay. And did she tell you were assigned to this homicide case?
You remember Lynn Beeland, everyone? Do you remember when we went over all of the invoices from trial number 1 of Karen Reed? Lynn Beeland was Michael Marcy's right hand. She quit and ran away after Karen Reed's first trial around the same time that the spokesperson for Norfolk DA's office also ran away and quit. And his name was, what was his name? Beeland and David Traub. His name was David Traub. They both left around the same time, and she used to rubber stamp all of the invoices for trial number 1. She was in charge of assigning the ADAs, I guess, to cases. And so that's what had happened in the King case. This is regarding Myles King's case from 2021. They didn't run away. They walked. They left skid marks. They ran so fast. Oh, no, my show with Samantha Benigno is going to be on Wednesday because that's her regularly scheduled live. And she's really busy this week, so we're going to do it on Wednesday night, so don't worry. And also, people are sending me emails about Rosemary Scapiccio. You're worried about her? She's on trial. Don't worry. She is still, she's fine. She just had said she was going to be on trial today for this hearing, and so they agreed to stand in for her because she's usually the one standing in for all the other attorneys. What I want to know is, has anybody seen Adam Lally? Do we have proof of life on Adam Lally anywhere? Is he still employed by the Norfolk DA's office? Because out of everything that we cover in Norfolk County, I have not seen him show up to court on anything. So if you guys know, if you work in there, if you know if he's in hiding or if he's still being assigned cases, let me know.
Yes.
And what does that mean to you, being assigned to a homicide case? What does that mean?
Well, I mean, at that point, it was an investigation. So as far as assisting with the investigation, should charges arise, handling the prosecution from there out.
Okay, so once you get assigned to the Myles King, Brianna Gardner case, is there a policy within the Assistant District Attorney's Office in Norfolk County on how to gather information that's required under Rule 14?
Objection. Overruled.
Does
A
the process,
specific policy, not that I'm aware of, no.
Okay, so there's no policy that you're aware of in the DA's office that that details how to gather information. Is that what you're saying?
Not that specific to that, no, not that I know of.
So how do you gather information, and how did you gather information in the King-Gardner case that was required under Rule 14? What did you do?
Objection. Just specify what is, it's too vague. Overruled. Question is, what did you do?
So what I
And I think we can take it in chronological order. We'll start at the beginning and then we'll have follow-up questions.
coffee runs?
Sure. So what I do is what I do in every case, depending on how many different departments are involved. In this case, there was a local department and state police involvement. So I would make appropriate requests for any and all information that they had, any information that, you know, specifically I could outline or delineate as far as what I felt was relevant. And
Stop right there. How would you make those requests?
Typically what I would do is write out a formal discovery request, submit the form to any involved departments, and communicate either via phone or email to whoever the relevant party was that I was requesting discovery from.
When you say discovery forms, what do you put on? What did you put on the form in this case for Gardner and King?
Initially, it would be for any and all police reports, any and all photographs, any and all information as to who was present, lab reports, if they had access to fire department, run reports, any lab personnel that responded to the scene, you know, so that I would have an idea as to whether or not there was testing that was going to be conducted or items had been recovered from the scene, copies of any and all search warrants, including applications, affidavits, copy of the warrants, any returns.
And let me talk to you. Do you have a memory in this case of asking for all the information that you just told you normally ask? Did you do that in the Brianna Gardner and Myles King case? Did you ask for all of that information?
Yes, and just for clarity purposes, when I'm initially doing this, it's not the Myles King and Brianna Gardner case.
It's just an investigation.
Correct.
Okay.
Well, and more to that point, Ms. Gardner didn't become a focus of the investigation until later on.
Okay. So while you were investigating without a defendant being a suspect, at least not initially, you asked which departments for this information?
The State Police, Norfolk County Detective Unit, as well as the Milton Police.
I can't hear you. What was the last one?
Milton Police.
Milton Police. Okay, so you asked Milton Police, you asked the State Police. Who in Milton Police did you ask, and who in the State Police did you ask to send information?
The Milton Police would have been, at that time, Lieutenant Michael Collins. The State Police would have been Trooper Michael Proctor, as he was a case officer, and Lieutenant Brian Tully.
In the document that we just read, the Commonwealth said they turned over all emails between LALLY and Proctor, LALLY and Tully, and LALLY and Milton PD. So they've got them.
And so you have emails going to all three of them asking for all of the information that you just listed, which would be normal information that you'd ask in any case after a homicide. Is that right?
Yes.
And did let's just take Mr. Proctor, Trooper Proctor, did he respond to you?
Yes.
And what did he provide you?
At varying...
No, to the extent he recalls, he can testify.
So at varying times, there were different productions of material, whether it was what was available at that time. So initially it would have been just whatever reports were available at that time. Later on would have been photographs, video.
So how often would you say you emailed or communicated with the State Police, and specifically Trooper Proctor or Trooper Tully, regarding discovery in this case?
I cannot tell you how many times via email, but I mean, it was a constant conversation, particularly throughout the grand jury process as far as discovery was concerned.
Okay. So when you say a constant process, was there a time period where you asked for stuff and you didn't get it, so you were re-asking for it, or is it always new information that you're getting from the State Police?
I think it would vary. I think there were certainly items that I probably had to ask for more than once, but there were definitely items that I had asked for and was provided promptly, and then moved on from there to either additional information or that avenue was complete.
So do you keep records of, I asked for search warrants, I asked for crime lab stuff, I asked for witness statements? Do you keep records when you receive that information to be able to check off to say, I got these things, they're no longer outstanding, and the rest of this is?
I mean, I keep records in the sense of a list of items I'm looking for, and obviously when I receive something, then yeah, that would get checked off the list as far as I'm not looking for that anymore because I have it.
Okay. So if you got a set of grand jury minutes from a witness that you know testified in front of the grand jury, you'd check that off your list?
Well, as far as yes, I mean, I was at the grand jury, so I know who testified at the grand jury, but as far as receiving the minutes, yes, I'm aware of the dates, and when I receive the minutes, then that would check that off the list.
I missed, I think, a question and answer, one question earlier. I think the question was, do you keep records of what you requested? What was your answer to that question?
So records, as far as what was requested, I would always have, at least in some form, some sort of running list of items I was looking for, and then if I received an item, then that would be something that would be off the list. Now, that list would be obviously added to as information develops, and there might be additional items that I'm looking for.
And presumably because it's on the list, you've made the request?
Yes.
Okay.
And so you'd have, whatever's on the list, you'd have emails requesting that information, is that right?
Yes.
Okay. And then if they emailed back, you'd have checks off of your list that you got whatever it was, that, you know, maybe you were asking for 10 things and you got 5. You'd check those 5 things off your list, is that right?
Yes.
Is there any other mechanism you used to document what you got from, just right now we're talking about the state police, Trooper Tully and Trooper Proctor?
I'm sorry, any other mechanism of doing what again?
Keeping track of what they're producing for you. Is it all just emails and check marks on a list? Or is there some other way that you keep track as well?
No, I mean, it would be something that I would have a list of items that are outstanding that would be, you know, followed up on if they hadn't been received at that point, and then I would follow up with whoever the appropriate person was to get copies of those.
And these lists remain in the file?
Proctor?
Your lists with the check marks remain in the file?
To the best of my knowledge, yes.
Okay. And have you reviewed any of them before you testified here today?
No,
Okay. Is there a reason you didn't review the file before you testified here today?
I don't have the file.
You work for the DA's office, right?
I do.
Yeah.
And it's in the DA's office, right?
Yes.
And you knew you were going to be asked questions about this case, right?
Yes.
And you didn't do anything to educate yourself about what you did initially on the case?
Objection. This is her witness.
Well, I'm not sure I agree with that as an objection, but I'm going to sustain the objection as to the relevance. He did not review the file. Next question.
So what did you review?
He's coming to testify specifically about what he did with discovery in the Myles King case. And this is an evidentiary hearing on a motion to dismiss, which we did not get in Karen Reed's motion to dismiss, which in my opinion and Bettero's opinion and a lot of other lawyers' opinions should have been granted with regard to what happened to all of that missing, magically appearing evidence in the Sally Port before Karen Reed's second trial. Judge Cannoni just denied it on paper without ever having an evidentiary hearing. Krupp, to his credit, in Myles King, ordered this evidentiary hearing so that LALLY could come in and testify about why he did not turn over the original search warrants that he had in his possession for 6 years. And he knew that that's what he was going to come in to testify about, but he didn't even see the need to take a look at the file so that he could testify intelligently. Let that sink in.
Reviewed in preparation for your testimony here today?
I reviewed portions of the file. I reviewed some of the items that have been produced by ADA Hickman. I reviewed search warrants. I reviewed police reports. I reviewed, you were asking specifically as far as checklists or notations. I didn't review those, but I did review, I have portions of the file. I have access to the file, and I did review portions of the file.
Okay. So you did review portions of the files?
Yes. Oh, yes.
You just didn't review your checklist?
No.
Okay. Now,
that was a backpedal if I've ever heard one.
In terms of the Milton Police Department, do you also have emails going back and forth to the Milton Police Department asking for certain documents?
Yes.
And who in the police, would that be Lieutenant Collins?
Yes.
Anyone else in the Milton Police Department were you looking for documents from?
On this case, I don't believe so, no.
And did you keep the same type of list that you kept for the state police of outstanding things that you were looking for the Milton Police Department?
Yes.
And what did you get back from the Milton Police Department? Do you remember?
Items of similar nature that they had access to as far as police reports, photographs. I don't believe Milton did any of the search warrants in this case.
The search warrants. He sounds so unbothered by this, doesn't he? And keep in mind, Myles King is facing life in prison, right? These defendants are facing life in prison, but I have a little checklist. Sometimes I check, sometimes I don't. No big whoop, no biggie. He sounds very unbothered. You're right.
But other items of discovery, video that they recovered, that there's a litany of different items.
A litany of different items? Did you
Yes.
say? Okay. And those would all be memorialized by email? Is that how you did it?
Yes, that's, I think, what Mr. McGee attached as Exhibit 1. It's about 137 pages.
Of emails back and forth between the Milton Police Department and you?
Correct.
And so at what point do you know that you have all of, so other than, strike that, Milton Police, State Police, any other person or entity that you sought information for in this case?
Certainly.
I'm sorry?
Yes.
Who's that?
Be the Office of the Chief Medical Examiner, be the State Police Crime Lab. There were some items that were outsourced to Bodie Technology Lab in Lorton, Virginia, where they did some additional forensic testing pursuant to DNA. They have different methods that our lab does not.
Bodie is
Milton
their
Fire
go-to.
Department, I believe Fallon paramedics were involved in the transport of the victim, Mr. Simmons. That's all I can think of at this point.
Okay. And would you communicate with those agencies the same way you communicated with the State Police and the Milton Police via email?
For the most part, could have been a phone call on some of those
All right, so let's stop
issues.
there. If there was a phone call, how did you memorialize what you requested and what they said in a phone call?
Notes.
You have individual notes.
Yes,
And where would those notes be right now?
in the file.
Okay. So do you keep like a running page of all the notes that you've taken in the case with communications that you had with all of the other entities and officers in State Police in this case?
Not all in one location, but it would be sort of divided up by different entities as far as what I was requesting from that specific entity and what I was looking for, what I was still waiting for, what was still outstanding, things of that nature.
Okay. So what happens when you ask for something, let's just say from the State Police, and they don't give it to you? What's the next thing you do?
The next thing I do would be to ask for it again.
Okay. How many times do you
Again
ask
and
for
again
it
and again.
before you have a meeting with the State Police to look at their file?
Objection. The biggest objection I have here is that we're not speaking about any individual document, any individual date, vague questions about
Yeah, this is general practice,
General
generally Mr. Lally's practice. I think part of the issue here is we don't have very specific items that are being referred to.
Right.
But I think I'm going to overrule the objection and give Attorney Scapiccio a little bit of leeway here in terms of general practice.
So in general, how many times do you email for the same document before you go to the State Police and start to have a sit down with them?
I think it varies. I think it would be depending on a lot of different factors as far as what the item is, what the explanation is for why I don't have it yet, whether it's not available or whether it's something that they're currently working on, or if it's something that I know has been completed and I've asked for it multiple times and I still don't have it. I'm not saying that even happened in this case, but if in a general practice, if that were something that were going on, then yes, I would want to sit down with somebody and figure out exactly what's going on.
Okay. So let me ask specific questions about this case. When you reached out, let's start with Trooper Proctor. In this case, looking for information, and there were emails back and forth. Were there any occasions where you did not get the documents or the information that you were seeking from Trooper Proctor?
I don't recall anything specific other than if it was a situation where I'm looking for a report about something and that report hasn't been completed yet or that item hasn't been obtained yet for whatever reason. But I don't recall in this case ever asking for something and just not getting it.
Do you remember asking Trooper Proctor for the search warrants that he did in this case?
Yes.
And the affidavits accompanying the search warrants?
Yes.
And did he provide them to you?
What I received was a partial affidavit for search warrant.
Stop there. Did he provide them to you, yes or no?
Some.
How many search warrants do you recall there being in the King Gardner case?
In 2021 or beyond?
Let's start with 2021. How many search warrants? You guys pulled the search warrants?
6.
6 search warrants. Did he, when you asked, and he signed all 6 search warrants, is that fair to say?
That's my understanding, yes.
Okay. And so when did you ask Trooper Proctor for the search warrant?
In July or August of 2021 when they were filed for.
Okay. And when did you get all 6 search warrants from Trooper Proctor?
I didn't get all 6 search warrants from Trooper Proctor.
You did not?
I did not.
Okay. So
you never
did
got
you get 1 search warrant from him?
From him specifically, I received a portion of the affidavit for search warrant 306 and the entire affidavit for search warrant 348.
Okay, so you got portions of 2 search warrants, and you knew there were 6 search warrants, is that right?
Yes.
Did you make notes somewhere in your file? Geez, I asked Trooper Proctor for these 6 search warrants, and he hasn't given them to me yet?
I believe, yes.
Okay, those notes are in your file?
I believe so, yes.
Okay. And then when you didn't get search warrants from Trooper Proctor, did you meet with him?
Yes, I mean, specific to that, I don't recall any specific meeting related to search warrants, but we did meet several times in relation to this investigation in this case.
But you understand that search warrants are Rule 14 automatic discovery, right? And you knew there were 6 search warrants, right?
I did.
And so when do you realize that you don't have all 6 search warrants? How long into the process? Do you know right away you don't have them all? Or do you not know for a long time you don't have them all?
I don't think I realized at that time that I didn't have them all.
So how, I guess I'm confused.
So are you just incompetent? Are you grossly negligent? Are you intentionally withholding them? Or do you just not give a shit? Those are your choices, A, B, C, or D. Or all of the above, I guess.
About how your system works. You said you had a system where if you asked for something and you didn't get it, you would then follow up with the police officer asking again and again. Did you do that with Trooper Proctor in this case with the 6 search warrants?
Yes, I believe so.
How many times did you email Trooper Proctor asking for the 6 search warrants?
I don't know.
More than 10?
I don't believe so, no.
Okay. How far in between each email? Did you wait a month and email him again? Did you wait a week? Did you wait a day? How long in between your requests to Trooper Proctor to produce the 6 search warrants in this case?
I don't know.
I don't know.
You don't?
No.
I think he's like the president of the We Do Not Care Club. He should follow our friend, our other friend, Melanie, who has started the We Do Not Care Club for women in perimenopause and menopause. He's a member of the We Do Not Care. He just doesn't care. He just doesn't care. This case was taken away from him, I think, in October of 2024, if I recall correctly, and reassigned to one of the other ADAs in the office. But he just does not care. Christine, thanks for your super chat, says, Melanie, I think there will be incriminating stuff on Proctor's phone about John O'Keefe's death that will open the entire case up. What are your thoughts? There very well could be. There very well could be. Absolutely. Because in their papers, the Commonwealth said there is some stuff that we deem to be necessary to perhaps turn over to independent law enforcement agencies. Read between the lines. Also, Higgy is saying, "Hi, Liz. I am ATF." A step up. Oh, Higgy's got game now, huh? Marianne says, if they could retrieve Proctor's info from the cloud, why didn't they do that to Higgins and Brian Albert? Proctor was a lead investigator on this case. Higgins and Brian Albert, even though they were law enforcement, were not involved in the investigation of that case. And although Karen Reed's team did make several motions, they're called Rule 17 motions to try and get the records of third parties, they were never granted. And so they just couldn't. And I guess you're referring back to the Karen Reed case because Higgins and Albert were not involved in the investigation of Myles King and Brian Walshe, so they would not be relevant to these cases. But now that we know what we know about Proctor's phone dump, there could be communications in that phone dump between Brian Albert and Michael Proctor, or Brian Higgins and Michael Proctor, because when Brian Higgins printed up all of his text messages to bring over for his interview, after he went over to the FBI kiosk and his friend Matt Kelch taught him how to use the extraction machine, where he cherry picked his messages with Karen Reed and or John O'Keefe and brought them to his interview to give his statement, didn't he come and meet with Proctor? Refresh my recollection. Was it Proctor and Buchanan that interviewed Higgins? So yes, there may have been some communications with Michael Proctor from Higgins to Proctor about like, hey, yo, I'm going to go, print out I don't know, maybe, could be. Bridget says, Jelly of the Month Club, the gift that keeps on giving. Flavors, Proctor Jelly is getting spread across multiple cases. Yes, yes, yes. Thank you, Bridget, for another super chat. Better O Groupie says, anyone else hearing Judge Judy's voice? Where did you think you coming today? Oh, yeah, Judge Judy. Thanks for your super chat. And Tracy, how do you go to the grand jury without the search warrants? They did have them at the grand jury. I think she's going to get into that. Let's listen. Thanks, Tracy.
Did you review your emails before you came here today?
Some of them, yes.
Did you see any emails to and from Trooper Proctor regarding the search warrants?
Yes.
How many did you see?
I don't recall.
More than 5?
Yes.
More than 10?
I don't know.
What are the dates of the first time you asked Trooper Proctor for the search warrant?
Specific date, I don't know.
I don't know.
How long before the next time you asked him for a big search warrant?
I don't know.
Specifically, I don't know.
Was it months or weeks?
Weeks.
Weeks later. Okay,
Yes.
so that's 2 times you asked him. What about the third time? How much time went by?
I don't know.
Months or weeks?
I don't know.
What about the fourth time?
Again, I don't know how many times and I don't know specific dates.
I don't know.
My question is, how does...
I don't know. I don't care. I'm the president, vice president of the We Do Not Care Club, and he just doesn't care. Like, his attitude is beyond. This is from July 21st of 2025. It is scrolling along the bottom. We are rewatching because we just looked at a new pleading.
your system works if you're not getting the discovery that you're asking a police officer for, and you're asked for it, let's just say 5 times. What do? Do you go to the office and you sit down and say, give me these search warrants, I have to turn them over?
Yes.
You did?
Yes.
Did you do that in this case?
Yes.
You go to Super Proctor and say, give me the search warrants because I have to turn them over.
Yes.
When did you do that?
Sometime prior to the defendant's arraignment in December of 21.
Oh.
November of 21, did you say?
December of 21.
December of 21. So when you get to his office, do you go there or do you tell him to come to your office? I don't know how that works.
Either way, I don't
Remember
remember.
how you met about the search warrants the first time?
In
other words, did he come to you or you go to him?
I don't know.
Okay. So you have a sit down.
Yes.
And you ask him for the 6 search warrants, and what does he say?
Okay, you will get them to me.
He will get them to you.
Yes.
Okay. If you tell him I have an obligation to turn this over because it's Rule 14 discovery, I need it right away, I've asked for it 5 times, what's the deal?
Those specific words, no, but the gist, yes.
Well, tell me what you said specifically.
I don't know.
I don't know.
Well, give me a best estimate of what you said to Trooper Proctor after you asked 5 times for search warrants that he didn't turn over.
Sustained.
So, did you keep any notes?
Remember, his lawyer was in the room, LALLY's. And the answer I don't know, is something that I never expected to hear an attorney say on the stand. Maybe I don't recall what I said, but I don't know. Very, very odd. Very odd.
Of your conversations with Trooper Proctor when you were asking for these 6 search warrants that he didn't give you?
No.
Why not?
It was something that I knew that was outstanding. It was something that I had asked for in written form numerous times. I didn't feel the need to write a note that I asked for it again.
So that's the first sit down. Did you send emails after the first sit down saying, hey, you promised me you're going to send these 6 search warrants, I still don't have them?
Objection, assuming facts.
Overruled.
I'm sorry, could you repeat the question?
Did you send another email to Trooper Proctor after you had the sit down at sometime in December of 2021 saying, hey, you still didn't send those 6 search warrants, can you send them over?
Yes.
How far after Mr. King's arraignment in December of 2021 did you send that email to Trooper Proctor?
I don't know.
I don't know.
Was it a year?
I don't think so, no.
What do you think? What's your best estimate of when you sent that email after you sat down with Trooper Proctor?
I would say probably a few months later.
All right. A few months.
Yes.
So February, March of 2022, is that what you're thinking?
I don't recall specifically.
So when you're in this room with Trooper Proctor asking about the 6 search warrants, do you ask him for his file? Like, give me your whole file so I can go through it and figure out what's in it?
No.
Why not? You're there. There's outstanding discovery. You have the obligation, not the police officer. Why don't you ask?
I entrusted that whatever discovery I was requesting, I would get at some point in a timely fashion and then turn it over.
Oh.
But you didn't get it. You asked for it 5 times.
You entrusted. You put your trust in the wrong guy. Do you think he took sighing lessons from Judge Cannoni? And notice also this is on normal speed. I didn't speed it up, which I normally would do, but Rosemary Scapiccio speaks so quickly that if I sped it up, you wouldn't even be able to understand her.
You didn't get it. You had to go see him. You have him right there now, and you still don't say, give me your file? Let me go through it?
No, I did not.
And when he says you'll get the search warrants, I'll send them to you.
Not a Karen.
Did he have them? Did he have copies of the search warrants? He just wasn't giving them to you?
That I don't know. You'd have to ask him.
Well,
you'd have to ask him. He's in the hall.
You don't get the search warrants in any event after that sit down, and you send another email. What's Trooper Proctor's response to that email?
Again, I don't know that I sent another email, but I know that there were subsequent conversations about it. Whether it was what format it was in, I don't know.
Ooh.
Okay, and at this point, you have to be getting.
Maybe they're in Proctor's new phone dump. Maybe we'll find out that way, Mr. Lally. Because he just says, I don't know. So that when the receipts are shown, he can't say, well, I said I don't know. But there's the receipt. So he can't lie, right? He's just going to say, I don't know.
You know, a little upset with Trooper Proctor that you're asking for information that he's not giving you, right?
Objection.
Overruled.
I'm sorry, your question again?
You have to be getting a little upset at Trooper Proctor that you're asking him for information that he's not giving you, right?
I wouldn't say upset, frustrated probably.
I'm sorry?
Frustrated probably.
Oh. Judge, can we approach sidebar just briefly? I know.
Sure.
You want to do a sidebar?
In any event, ADA Lally, a couple of months goes by, you still don't have the 6 search warrants. What do you do?
I don't know. I mean, I'm specific to the 6 search warrants. I don't.
The silence.
I don't recall as far as there was a topic that was discussed repeatedly. Obviously, I never received them because I never provided them to you or to Ms. Costa.
Oh, at least he admits that.
Okay. So I guess what I'm saying is you knew they existed and you knew that, let me just say, you knew that all 6 search warrants existed. Is that right?
Yes, we went through all six of the search warrants on the last day of the grand jury presentation on November 19th, 2021. That's in the grand jury minutes as far as going through each of the materials, each of the search warrants, that they were search warrants, how that material was obtained, and the material that was returned in response to 3 of the search warrants was marked as grand jury exhibits 33, 34, and 35.
There you go, Tracy. There's the answer to your question. There's the answer to your question. He did go, he had him at the grand jury. So he had him in 2021. And then what had happened was, I don't know, he just lost them. Did they get hidden in the same drawer as the inverted Sallyport video and the lost Sallyport video? Is there like a lost and found drawer over there at the MSP or the Norfolk DA's office, a lost and found?
Correct. Well, no, actually, I'm sorry.
Information in front of the grand jury about 6 search warrants that you hadn't seen, and you put returns or information that had been returned in front of the grand jury on search warrants you had never seen.
So with
Answer that question.
And I'm trying to. So
Okay.
with regard to those 3 search warrants, that was 306, 307, and 329, which were the call detail records for your client, the victim, Mr. Simmons, and Mr. Jeanette. The materials that came back from the cell phone providers also contained a copy of the warrant, as well as the addendum to the warrant, which was then also provided to you and Ms. Costa in discovery.
But not the warrants themselves.
No, the warrants themselves and the addendums, not the application and not the affidavit.
Right, so you understand that in order to make a determination as to whether or not you're going to suppress certain information, you actually need what you asked for and what you, in the affidavit that told the clerk magistrate why you had probable cause, right?
Objection.
I can take judicial notice of that, and I'm sure Mr. Lally knows that.
Okay, so you get in front of the grand jury. When do you present this case to the grand jury?
Began in July of 2021. That grand jury sat in July, August, and September. The presentation had not been completed at that point, so there was a motion to extend the grand jury. And I believe there was one subsequent date that we went before them on November 19th, 2021.
November what?
19th, 2021, that's when indictments were returned.
In 2021?
Correct.
Okay. So at some point when Mr. King is arraigned, you understand at that point Rule 14 kicks in, right?
Yes, I mean, I'm thinking,
right?
I'm thinking about Rule 14 well before that.
Okay. And you know, when you arraign Mr. King, you still don't have the search warrant. You have another conversation with Trooper Proctor about, hey, where are these search warrants? I have to turn them over.
I'm sure I did.
And do you know when that would have been?
I don't.
Okay. And then, remember at some point in December of 2021, receiving a discovery notice from me. Hey, Brooke, what are you trying to?
Yes.
This is just my discovery notice.
Is that a discovery motion, or what is
Motion,
that?
I'm sorry, motion, Judge.
Yes.
Okay. And do you remember, after having filed this motion, you asked the time to go through and make sure that you can comply with all the requests, right?
Yes.
And you didn't have any specific objections to anything that I was asking for, right?
At that time, no.
Okay. May I approach the witness, Your Honor?
Yes.
Sorry, Judge.
Is that an exhibit? Is that a docket entry?
It is a docket entry, Judge.
Do you know what it is?
I think it
Or we can mark that just so that there's a record of what you're showing the witness?
has my writing on it, Judge. So
All right,
I want to
so-
mark it. But I'll do it after the hearing. I'll find the exhibit and I'll make a clean copy and send it to the court, Judge. So once you get the discovery notice, you know for sure that there are certain categories of information that we're looking for, right?
Yes.
And number one is all automatic mandatory discovery under Rule 14, right?
Correct.
Would you consider those search warrants automatic mandatory discovery under Rule 14? Okay. And we were looking for any and all statements of witnesses, is that right?
Yes.
And we were looking for all exculpatory information, whether
The
tangible.
document speaks for itself.
Okay, that's fine, Judge. So after I filed this motion to December of 2021, you have another conversation with Trooper Proctor saying, give me the 6 search warrants.
I'm sure I did. My general practice is if there is any discovery motion that's filed by counsel, what I'll do is I'll send that to the appropriate police personnel as far as making requests and making sure that they're apprised of what's been at least asked for.
Excuse me, and did you do that in this case? Did you send my motion for discovery to Trooper Proctor, to the Milton Police, to the crime lab, to the medical examiner's office? Did you send it to all of those entities?
Every motion that you filed, yes.
Okay. And then what do you do to follow up with each of those entities? Let's start with the state police. They get a copy of my discovery motion. You're looking for all of the evidence that they have, and specifically these 6 search warrants that, for whatever reason, Trooper Proctor hasn't given you. When you follow up, how long does it take you to follow up from the time that you give them the motion until you get an answer from them?
Specifically, I don't know. Typically, I would give it a couple of weeks or so.
And after a couple, and in this case, did you give it a couple of weeks, you think?
Probably.
Okay. And then what happens?
And then I'll follow up again.
When you say follow up, do you send another email, or do you get in your car and drive down there and say, we got to end this, give me this stuff?
I email or a phone call.
Okay. And so did you email or phone call, or make a phone call to Trooper Proctor in this case?
I'm sure I did.
And what was his response?
I don't
when
recall.
you asked for the 6 search warrants?
I don't recall.
Well, do you have any notes of your conversation with him? Remember you taking notes?
I don't believe so, no.
Is there a reason that you didn't take notes when you spoke to Trooper Proctor after these search warrants had become an issue? That you wouldn't take notes of what Trooper Proctor told you about the search warrants?
So you're asking me about a conversation that I don't recall specifically when it happened or exactly what was said. So whether or not I took notes for that conversation, I don't know. What I would do typically in my general practice is to follow up with whoever I had outstanding discovery requests in relation to try to get whatever information that I was seeking.
Okay, and so did you follow up with Trooper Proctor about the 6 search warrants?
I'm sure I did, amongst probably a number of other items.
Okay, and then you knew this case was going in for another date on discovery, right?
Yes.
And you knew you'd have to answer to the court what you've provided and what's outstanding. Isn't that typically how it goes on discovery dates?
Yes.
Did you ever tell the court, geez, I have these 6 search warrants that Trooper Proctor has, I can't get my hands on them? Can you issue an order, or can you help me out here?
Did I do that? No.
So when you went to court, do you remember representing to the court that discovery was ongoing and that you were producing as much information as you could? Remember that?
Typically, that's what I would say if that was the case, yes.
Okay. But you knew when you represented that to the court that you didn't have the search warrants, right?
Yes.
So what was your plan? How are you going to get them?
As I stated, what my practice would be if there was some outstanding item of discovery, I would request it and follow up if I hadn't received it.
But you did that. You requested it 5 times. You went to see him. Then you got my discovery motion. You sent that to him. You waited another month. And then what happened?
I don't recall.
See how this is like pulling teeth, trying to get an answer out of this man, trying to get any answer out of this man. It's like pulling teeth. Rosemary Scapiccio should moonlight as as a oral surgeon, because it's insane. He doesn't remember anything, except he knows he had the search warrants at the grand jury, but he never turned them over. That's why Myles King was let out on bail, and he's out now. And he potentially could be maybe a murderer. And if it comes true that there are racist text messages on Proctor's phone regarding that defendant, Myles King, he could just skate.
Well, don't you tell him, get me these things now, I'm coming down your office?
Objection.
Overruled.
I have a feeling that Proctor is the boss of him. I don't think he's the boss of Proctor. What do you think? Who do you think is the boss in that? Who do you think wears the pants in that relationship? Proctor or LALLY? She's like, yeah, don't you go down there and say, I'm coming down to your office right now? Me thinks he might be afraid of Proctor. I don't know.
Objection.
Overruled.
Did I ever tell him that? No.
Wait,
and then what happened?
I don't recall.
Tully.
Well, don't you tell him, get me these things now, I'm coming down your office?
Objection.
Tully.
Overruled.
Did I ever tell him that? No.
Okay. So what do you do when he's not complying with your request? Let me ask you this. What's the policy in the office of the District Attorney's Office in Norfolk County when a state trooper is not complying with a request for discovery?
Objection.
Overruled. If there is a policy,
What's the policy?
Give him an out.
I don't know any specific policy related to that.
Yeah, the policy is do whatever Tully says. Do whatever Tully says. Oh, I can't wait for these messages to come out. I can't wait.
So do you go to your supervisor then and say, hey, I've asked Trooper Proctor 5, 6, 7 times for these search warrants. I've been down to see him in person at least once. He's not giving them to me. What do I do?
No.
Did you ever have another case other than Mr. King and Ms. Gardner's case where a state trooper didn't give you search warrants that you had been asking for since before indictment?
Objection.
Overruled.
Not that I recall, no.
Okay.
Your Honor, may I be heard on one slight issue? The discovery, the discovery request the counsel is speaking to, I don't believe that it was ever docketed. I don't have a copy of it. I've never seen it. So
The motion, the motion?
The motion for discovery was filed. He got.
Well,
it may not have reached the docket, as I guess.
I want to make sure that you see it, though. Let's make sure you...
Speaking about it a lot here, and
No.
I've never seen it.
Attorney Scapiccio, can you just give it to Mr. McGee for a second?
Sure. You think it would be in the file?
I would think it would be in a file. Is that a clean copy?
That is a clean copy, Judge.
Can we mark that? Should we mark it?
It's unsigned, and it's probably, I don't know if it's a draft or a,
Oh, the non-signed, all right, so let me get you a signed copy, Judge.
I don't know what was.
The bottom line is, this witness said he received it, Judge. I know I wouldn't have not filed it. We talked about it in the hearing. And I think there is a transcript, Judge, of a hearing where we talked about the discovery motion, and the court had it.
All right, we'll
in front of it.
figure that out.
Can you guys sit there?
We do have the ADA Hickman did have a copy.
You do have a copy?
I never saw it on the docket. I was working right off the docket.
Okay. And just so the record is clear, we have marked it? You want it marked as Exhibit 1 in this hearing?
Yes, sir.
Sure.
All right.
Get you a signed copy, apparently.
All right, that will be Exhibit 1.
Thank you. I'd also, at some point, Judge, like to mark the pretrial conference report in this case.
Thank you.
So this had never happened to you before, Attorney Lally, and you didn't go to Lynn Beelan, who was your supervisor, and ask her what to do. What was your plan? How were you going to solve it?
I don't recall specifically having a plan. If there was a situation where I was asking
There's no plan.
a trooper or a case officer for something and I had not yet received it, I might get that person's supervisor involved. As far as saying I've asked for this a few times, I don't have it.
Okay, so let's stop there. Trooper Tully was Trooper Proctor's supervisor, is that right?
Yes.
Did you go to Trooper Tully and say, hey, I don't know what the deal is, but I can't get these 6 search warrants from Trooper Proctor. Can you have him send them to me?
Specifically about the search warrants, I don't recall.
You didn't go to a supervisor.
I don't know if I did or I didn't.
But as you sit here today, you don't remember.
Oh, his supervisor would be Tully. Oh. You think there's any communications between Proctor and Tully where they're like, Adam Lally is such a little bitch. Tell him to get off my back and stop asking for shit. I'm busy. I don't want to deal. Tully is the supervisor. I don't want to deal with Lally. He's so annoying. He's so annoying. I got to hear that again because that's who it is. It's Tully. Good for him that he kept saying, I don't recall, because when those communications surface, Lally could be talking himself into like I don't know, some sort of like, ethical proceeding, maybe. Lally's been working with that rules or protocols for decades, says Bailey. He's been with the DA's office since, what did he say, 2005? It was his first job ever. He's been there for 20 years. It's the only job he's ever known. Never in private practice. He was never a defense attorney. He's only been with the Norfolk County DA's office. That's it. It's where he was trained, born and raised, NCDAO. Might you get that person's supervisor involved, like Tully? Listen.
And I had not yet received it, I might get that person's supervisor involved. As far as saying I've asked for this a few times, I don't have it.
Okay, so let's stop there. Trooper Tully was Trooper Proctor's supervisor, is that right?
Yes.
Did you go to Trooper Tully and say, hey, I don't know what the deal is, but I can't get these 6 search warrants from Trooper Proctor. Can you have him send them to me?
Specifically about the search warrants, I don't recall.
You didn't go to a supervisor.
I don't know if I did or I didn't.
But as you sit here today, you don't remember going to a supervisor, is that right?
I know that there were a number of meetings in relation to discovery that Lieutenant Tully was present for, along with Trooper Proctor, but going specifically to his office to demand 6 search warrants, I don't recall that.
Okay.
Yes. Kelly says, I wonder what lies are on the search warrants that they don't want anybody to see.
How much time goes by before you ask for the search warrants again?
I don't know.
Is it a year?
I don't know.
During the time period, it's fair to say that we were appearing in court every couple of months on discovery, right?
Yes.
Did you ever notify the court on any of those court appearances that you were having trouble getting custody of the 6 search warrants that were issued in this case?
No.
Okay.
She knows because she was there.
Now,
she was at every conference.
you talked about having meetings, discovery meetings. Tell us what those are.
At various points, probably more towards the early stages, or if there's something that's significant that comes up, it would be just a meeting in relation to, this is the discovery that's outstanding, this is what I'm looking for, what's the ETA on this, when should I expect to receive this?
And are those meetings in person or on the phone?
Typically in person.
And do they take place at the DA's office or at the state police?
Well, I mean, in this specific instance, the state police is attached to the DA's office, so it's the same building. So
Yeah.
whether it was
They're attached,
my end of the
all
hall,
right.
their end of the hall, I don't know.
Okay. And do you remember discussing the search warrants and the outstanding nature of the search warrants at the first discovery meeting?
Yes.
And what was the response?
That the search warrants are still ongoing, as some of those search warrants were not just July, I believe it continued into probably September of 2021 as far as the last of the search warrants. I could be off on those dates, but
So how many motions or how many meetings do you have regarding discovery before the return or before the return of the search warrant in July of 2021, if that's the date?
not many. I mean, the murder occurs on July 10th, so there's not a lot of time in between that. So probably 2 at the most.
2, okay. And you don't take any notes on those meetings either?
I don't know.
But I guess I can't figure out, how do you keep track? If you have this list that says all these things are outstanding and you're having these meetings because there's things outstanding, if you're not taking notes at these meetings, how do you know what people are saying and when to expect the discussion?
So if there was something that specifically was known as far as, this is what's going on with this piece, and anticipated sort of ETA on return or something, then yeah, there would probably be a note about that.
All right, so let's assume that the returns came back the latest July of 2021. Let's give you 3 months, August, September, October. October of 2021. Are you asking again for the search warrants that you still don't have?
We've been over this time period. I'm trying to figure out you went all the way through arraignment and on the number of meetings and emails back and forth. I get it, but maybe you want to cover new ground.
I'm just trying to figure out, let me ask a question. So when do you realize that you never turned over the search warrants? When do you realize that?
When, if ever?
As far as the 2021?
Back up. When do you get the search warrant in your custody?
In my custody?
Yeah.
I would say probably I became aware of it about a month ago.
A month ago?
2025?
Yes.
July of 2025 or June of 2025?
Yes.
Is the first time you became aware that you didn't turn over the search warrant?
Wow.
Yes, if I had been aware earlier, then I would have turned over the search warrants.
But you had your list, right?
There it is. There's incompetence at the highest level, okay? Well, if I had him earlier, I would have turned him over sooner. Wow. Thank you, Anton, for your super sticker. Kay says, will we eventually be able to hear all of the damaging stuff on Proctor's phone? Could it all be impounded? The Commonwealth said they're going to move for a protective order. We'll see if the judge grants it. Thank you, Kay Willis, for your super chat. Laura says, in the words of Buzz Lightyear, in the words of Buzz Lightyear applied to Lally, you're a sad, strange little man. Shout out to Microdots. I love you with all of my heart, Melanie. I love you too, Laura. Thank you. Just Me Gaiman says, I wonder when the governor will step up to take some responsibility and distance herself from this corruption. You mean the same governor that might have posted a video from like, I don't know, 8 years ago on Twitter saying that that was something that happened over the weekend with regard to some protests? That governor? How about never? Sounds like a snotty preteen, says Quinn. And Tracy says, DA and MSP attached per Pretty Woman. Big mistake. Big, huge, huge. Thanks, Tracy. You had your list, right?
You had your list that said 6 search warrants outstanding, right?
Yes.
You didn't ever check that off, right?
No.
So you knew they were outstanding, right?
Yes.
Okay. And then
it's painful to listen to, right? It's painful.
When did they get to your file?
Again, so as far as my file, they did not. Again, I became aware of it after the case had been transferred from myself to ADA Hickman.
That's
Well,
convenient.
let's talk about that. What date was the case transferred from you to ADA Hickman?
I'd say probably somewhere in October or November of 2024.
2024.
Yes.
And how does the case, let me just say in general, how does the case get transferred from one DA to another? Is there a policy within the Norfolk County District Attorney's Office of what needs to get done to transfer a file?
No policy, no.
Okay. So what did you do in this case with Mr. King and Mr. Gardner to ensure that your complete file got in the hands of ADA Hickman?
So I physically took the physical file from my office to ADA Hickman's office.
Okay. And did you have a conversation with her?
Yes.
And did you tell her, hey, there's 6 search warrants that I was never able to get from Trooper Proctor?
Again, if I had known or remembered that the 6 search warrants were still outstanding, then I would have got them and provided them. So no, I did not reference that specifically.
But then at some point, ADA Hickman has to come back to you and say, did you not turn over these 6 search warrants? Say that to you?
No.
She never did.
Nope.
Did you ever have a conversation with ADA Hickman about the outstanding 6 search warrants?
Not until recently, no.
Okay, and
no big whoop.
What transpired?
Objection.
Sustained.
Well, so when you told the court that discovery was almost complete, did you know when you made that representation that the 6 search warrants were still outstanding?
Objection.
I don't know what time frame we're talking about.
I also, as I've stated in my opposition, I've reviewed the FDRs on this from December and February and the other dates in 2025. That statement was never made. And then December.
He listened to the tapes. He listened to the tapes of the hearing. This is McGee. This is the guy who I said I had never heard his name before, and he signed off on that pleading from October, whatever pleading we were just reading, that I think was from October 9th. I don't know where Hickman is.
That's why I want a date.
In October as well, when Your Honor set this for trial. Thank you.
So when's the last time you remember answering on this case?
I believe it was December of 2024.
Could it have been January of 2024?
January 2024?
Oh, so let me back that up. In January 2024, were you still representing the Commonwealth?
Yes.
Okay. And do you remember there being a hearing regarding discovery?
Not specifically, but I'm
enough.
sure there
Okay.
were.
And do you remember, excuse me, do you remember the court asking about discovery and how the discovery was proceeding?
I'm sure it happened. I don't
I'm sure it
recall
happened.
that specific date or what was
Give a
asked.
shit.
Okay. And do you remember telling the court in January 2024 that you were hopeful that by March of 2024, we could proceed forward because discovery would be complete? Remember that?
I don't.
It's worse the second time, right?
Yes.
Grateful Little Farm. It's worse hearing this the second time.
It's from when? That wasn't able to.
January 2024.
I know.
The dominoes are falling, you guys. The dominoes are falling. This is from July. It's only been 90 days since this hearing. Think about it. This hearing was July 21st. It has been, today's October 20th, 90 days since LALLY was on the stand. And look at how much has happened. Look at how much has happened since then. There might be justice for John O'Keefe after all, you guys.
Yes.
I'm going to give you the transcript of the appearance before this court on January 24, 2024, and ask you to look on page 5. And Colleen, read that at the bottom of page 5 to yourself and the top of page 6.
That's right, Ann. That's why you guys come to YouTube, to get the facts and information and the court documents and pleadings and hearings that mainstream media won't show you. Thank you, Ann Merritt. Something is in the water in Norfolk County.
Yes.
Does that refresh your memory as to whether or not in January 2024 you told this court that substantially discovery was complete? There might be 1 or 2 items that are outstanding, but can we get them to us?
I didn't read that portion. I was reading the highlighted portion.
Oh.
If I could have a moment.
Sure.
Take all the moments. Kind of like you said in Karen Reed's case, that discovery was complete. You filed your certificate of compliance, and then you forgot to hand over all that hidden Sally Port video that MICHAEL Proctor had in a drawer, according to Judge Cannoni. How did Judge Cannoni know that it was in a drawer hidden by MICHAEL Proctor? There was no evidentiary hearing like there is here. She made that the judicial
I'm
determination.
sorry, I'm not seeing what you're
on her own
referring to in that.
Well, do you remember
transcript.
telling the court, Your Honor, I think as far as discovery goes, we're in a fairly good position. Did you say that to the court?
I may have.
Look at lines 16, 17, and 18 on the document that's in front of you, Ms. Lally.
And what page, Ms. Attorney
Page
Capito?
4, lines 16, 17, and 18.
Wow. No, he's got baby shark hair. We call that the shark hairdo, like when you're a little baby.
The court asks, where are we, Ms. ADA Lally? And you say, Your Honor, I think as far as discovery goes, we're in a fairly good position. Did you say that?
Again, I'm sorry. In the transcript that you handed me, I don't see that.
Let me see.
Wow. Oh, he's got baby shark hairdo. Like when your baby was in the bubble bath and they used to make like a shark with the bubble bath shark hair, fin hair. It's a choice. It's his choice. It's his fashion choice.
Do you remember, hold on, let me get this right.
Kyle, thanks for what you just sent me, but what case is that in? Is that in the, Kyle, is that in the Myles King case?
Do you remember telling the court, I was wrong, you were right. Do you remember telling the court there may be a couple of outstanding pieces, talking about discovery, that I'll check on, and some other pieces that I was speaking to Ms. Coster about, but I think hopefully that by March 11th date, we should be able to proceed forward. Remember saying that to the court?
Do I remember saying that to the court? No.
Does reading that refresh your memory that you said it to the court?
I didn't read that portion. What page are we on?
This is his custom habit and practice. He does it in every
From
case
here.
he did in Karen Reed too.
Over to here. To yourself, please.
And in Karen Reed, he was whining that he didn't get discovery from the defense, but he hadn't filed his certificate of compliance yet. And then all the magical Miss Larry Sally Port video surfaced after trial number 1.
Yes, that's correct.
Does that refresh your memory? Video rally that you indicated to the court that, get this exactly right, there may be a couple of outstanding pieces that I'll check on and some other pieces that I was speaking to Ms. Coster about, but hopefully by the March 11th date, we should be able to proceed forward. Did you say that to the court?
Well, those are two. So does it refresh my memory? No, but according to that transcript, that's what I said, yes.
Okay. And you know at that point that there were still 6 outstanding search warrants that you didn't have?
No, again, if I had known, then I would have gotten them and provided them.
Okay. But
okay,
weren't we talking about search warrants on this day?
You're talking about 2022 search warrants, which were in a subsequent notice of discovery related to a cell tower dump. You were provided all of those as far as the application, the affidavit, the return, and copies of the warrants themselves.
So we're talking about search warrants,
Separate search warrants, yes.
and nothing's ringing the bell that you didn't turn over 6 search warrants?
Apparently not.
Apparently not.
Okay.
He really doesn't
So the
care.
2022 search warrants that we talked about in court back on January 24th of 2024. At that point, Mr. King was indicted. Is that right?
Yes.
Was Ms. Gardner indicted?
Yes.
All right. So what process did you go through to issue the 2022 search warrants after indictment?
Through this court.
I'm sorry?
Through this court.
So you went to Superior Court.
We need to pause for a second for breaking news, courtesy of Kyle Sharkey. Breaking news is just filed in the Myles King case. MICHAEL Proctor's attorney has jumped ship. And so today, Daniel Moynihan has withdrawn for witness MICHAEL Proctor. There it is, filed today, October 20th. And that is, there's not even a docket number, but there's a notice of withdrawal filed. He's like, I'm not going down with this ship. I'm out of here. See this right here, attorney appearance. Daniel Moynihan, notice of withdrawal has been filed. He's like, I cannot in good conscience represent MICHAEL Proctor. So just in case you weren't here when this original hearing happened on July 21st with us, we had so much fun during this hearing that we're now having it. And again, we're having a replay. We're having another viewing party of this because we had so much fun the first time. MICHAEL Proctor was there in the hallway with his attorney, Daniel Moynihan, the same attorney who represented him in the commission hearings to get his job back, the same attorney who had him sign off on withdrawing his proceeding to try and get his job back. That's Daniel Moynihan. That's the one that we just saw Aidan Carney video of with Proctor outside of the courthouse. That was this same day, right? July 21st. Moynihan's like, yeah, you know what? I'm out of here. Because whatever, maybe, and an attorney has the obligation to ethically withdraw when it comes out that their client has been lying and they no longer in good conscience can continue to represent said client, because that would be a violation of the ethical rules. And so without telling the court why they need to withdraw, they file a notice of withdrawal and they say, Your Honor, I need to withdraw. If you need to know why, we can have you and I can have a little chat, a little ex parte chat alone, and I'll tell you why, but I'm not putting it in writing because it would breach attorney-client privilege. I don't know what it says because it probably hasn't been scanned yet, but thanks to Kyle Sharkey for telling me it was in the docket, and this is in the Myles King case. They're jumping ship one by one. The dominoes are falling. The walls are coming crumbling down, and we can all sing it together. Na 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 na. Hey, goodbye. You wonder why they're ramping up on social media? Do you wonder why? Because some of them and their sock accounts, and maybe some of their besties, people that they have, their self-proclaimed bested friends. Jennifer McCabe's self-proclaimed best friend is all over this cesspool of Twitter, trying to say mean things about me to distract you from the fact that maybe her best friend, I don't know, might be implicated in some of the things that were found in Proctor's phone dump. I'm just saying, maybe, in my opinion, I don't know. Back to the hearing.
Asked for these search warrants, is that right?
Myself personally, no.
Well, did you notify defense counsel that you were asking for search warrants in a case where a client had already been indicted?
No.
Do you know whether or not there's an obligation on behalf of the district attorney's office to notify defense counsel post-indictment if you're moving to request additional search warrants?
They weren't search warrants that were pertaining to the defendants. They were.
Do you know whether or not there is an obligation on behalf of the district attorney's office, you specifically, to notify defense counsel if you're seeking search warrants after indictment.
Objection. If this is a legal, yeah.
Sustained.
Thank you.
So in any event, we're talking about search warrants in January of 2024. You don't say anything about the search warrants that are still outstanding, those 6. And you tell the court there's only a few things that are outstanding then. Is that right?
Yes.
Okay. And then we come back, we suggest March, and we come back in March. Is that right?
I believe so, yes.
Okay. Then in March, do you tell the court, Your Honor, as far as discovery goes, we're in fairly good position. In regard to that, I believe that was turned over just prior at the last date, so there may be a couple of other additional items of discovery that I need to get and turn over. But otherwise, I think we're in a fairly good position. Did you say that to the court, sir?
I don't...
Finish, Your Honor.
Yes. These transcripts in the FTR, what's on the FTR, what was said by whom, when, is
you can't
all
make
a
this
matter
up.
of public record, and we can look at the FTR and get it. So specific quotes and what was said, what was represented, that's part of the record, and we can see
But I
that.
just have to set it up so I can ask the question that I want to ask, Judge.
Great.
Thank you. So after having made that representation to the court, did you do anything to get the 6 search warrants?
No.
What were the outstanding matters as far as you understood back in March of 2024?
I don't recall exactly what we were talking about on a court date in March of 2024.
Do you have any notes that would refresh your memory as to what was outstanding at that point?
I might.
And would they be in your file?
If they were anywhere, that's where they would be, yes.
Okay. Now, other than the discovery motion that we filed, did we also file a pretrial conference report in this case?
That I don't recall.
Okay. But you understand, normally we file a pretrial conference report where you agree to give me what I'm asking for, and we agree to file motions on stuff we can't agree on. Is that typically how it goes?
Yes.
Okay. And you don't remember signing a pretrial conference report? Not that you didn't, you just don't recall.
I don't recall every pretrial conference report I've signed.
Okay. And then we talked about the meeting with the state police. Did you have any meetings with the Milton police regarding outstanding discovery?
In-person meetings? No.
Did you send the Milton police the same type of discovery request that you would have sent to the state police?
Yes.
And did you follow up with the Milton police the same way that you say you followed up with the state police?
Yes.
And did you follow up specifically with Lieutenant Collins?
Yes.
And so what, in your mind, was outstanding on the Milton discovery that you were communicating with Lieutenant Collins regarding?
At what time?
Let's start at the beginning.
Again, it's the same type of information that you asked about before, as far as reports or photographs or any material that they might have pertinent to the case.
So whatever the Milton police turned over to you, would you have kept notes of that somewhere?
Yes.
Would there have been emails back and forth between you and Milton about what transpired?
Yes.
Okay. Did you have any trouble getting information from the Milton Police Department?
No.
When you asked for things, did they return your email and give you what you were looking for?
Yes.
Were there any reports from the Milton Police Department that you say you didn't have before you turned the case over to ADA Hickman?
There was one report, yes.
I don't see this,
And what was
Ellie.
that report regarding?
I don't
Turner.
see Kate Peter posting
Sorry?
that she's saying that Proctor's going on her channel this week. She had said that a really long time ago, but I don't see that anyway. If you want to email it to me, I just checked and I didn't see it. There's also another account that pretends to be her, so I don't know, maybe that's it. Proctor was not involved in Sandra Birchmore, as far as I know. Fanning was.
Mr. Turner.
And what about Mr. Turner?
There was a report in the materials that ADA Hickman turned over in 2025 that
was a retweet.
I
you.
believe, offered by Detective Sergeant Clifford Murphy pertaining to Mr. Turner that I had never seen before.
Okay. And do you know why that wasn't turned over by the Milton Police Department?
No.
Did you go down to the Milton Police Department and look through?
Okay, everyone is saying that is a screenshot of Kate Peters saying she was having Michael Proctor on her channel and somebody screenshot it and put it up again like, oh, I think it's time for you to have him on your channel. When are you going to have him?
Their file?
No.
At any point in time when you were representing the Commonwealth, in this case, did you go down to the Milton Police Department and look through their files?
No.
Is that something that you would normally do in a homicide case? Go to the police officer's office and ask for the file?
At what point in the case?
At any point.
Typically, that would be something that I would endeavor to do closer to trial.
Closer to trial?
Yes.
So how could you make sure your obligation was satisfied if you're not meeting with the police until right before trial?
An ongoing duty and obligation that extends even beyond a trial.
Right, that's not my point. My point is, if you're not meeting with them and you're not going through their information, how do you know you've turned everything over to the defense?
Because I've requested it and I've been given assurances or information indicating that that is what they have.
Let me ask you the same question about the state police. Did you ever go through the state police file?
It's infuriating.
While you were handling the case, as opposed to making requests and even sitting down with the state police to make, face-to-face requests on an ongoing basis and all the follow-up contacts that you had. Did you ever actually request their whole file to go through it yourself?
No.
Okay.
No.
And can you tell us, was there a policy within the Norfolk?
You think Krupp shut the hearing down? I mean, I wish he didn't shut the hearing down because I really, 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 really wanted to hear more. Do you think he shut it down because he's just going to dismiss the case? I don't think that the motion to dismiss has ever been ruled on, right? Is he going to continue a hearing? Is he just going to dismiss it? I mean, it's crazy. I give her so much credit for not just like losing it, not losing it and just starting like to go ballistic. Because her client was in jail for 3 years, awaiting trial. They finally had to let him out because it just took too long. And he's facing life in prison. The fact that she could keep her cool for this long with him, my patience was over with him within the first 3 minutes.
County District Attorney's Office of sitting down with police departments, whether it's state police or Milton Police, and reviewing their file prior to trial?
Not that I'm aware of, no.
Okay. So how far in advance of trial do you finally sit down and go through, let's take the Milton Police box?
It would depend, case to case, but it's something that I would probably do at least a few months ahead of trial.
A few months. And is that the first time that you put your hands on the actual box, or are you still dependent upon the Lieutenant Collins and other officers to give you what you're looking for?
Oh, that would be a time where I'm actually like, let me see the file and ensure that I have everything that you have.
Like,
is there any prohibition?
Trust me, bro.
To that meeting that you have a couple of months prior to trial happening right after indictment?
No, and that would be my practice now. So you're asking about sort of my general practice at the time. That would have been it at the time, but now I would do that much, much earlier in a case.
Yeah, because now you're getting spanked in front of a worldwide audience. If you are here, if you were one of the almost 8,300 people that are still in the chat and you are watching from outside the U.S., just to put a flag in the chat. Let us know where you're watching from, or tell us what country you're watching from, because the world is watching.
Okay. And the state police the same way? Did you sit down with them at some point and look through their file, or you never looked through their file?
No, as His Honor just asked, no, I didn't.
Okay. So I guess my question is, how did it work? Did they only look through their file and send you what you're asking for? Or at any point did they send you, here's everything that we have?
My request and my ask was for everything they had. So as far as me then double checking to ensure that I have everything they have, that would be something that would occur later on. And as I just indicated, my practice now would be to do that much earlier in the case.
Okay.
Buffoon.
So
what a buffoon.
When you go in this case, you knew we had picked a September 8th trial date, right?
I was aware, yes.
Okay. So you knew the case was ready for trial on September 8th. When were you planning on sitting down with the Milton Police and going through their file?
As the case was reassigned to ADA Hickman around the time that we selected the trial date, I don't know that I had a specific plan to do that. I did have a specific plan to meet with ADA Hickman to go through the file to ensure that she had everything that was there.
Really? It's out of my hands for
So
now.
when by the time she had taken over in January of 2025, you had not made any plans to sit down with the Milton Police to go through their file, is that right?
She had taken over prior to that, but no, I hadn't.
Okay, and the same with the state police, is that right?
Correct.
Okay. So when you're updating ADA Hickman, when she takes over the case, do you tell her, I've never actually seen the files, it's on my list of things to do, but I never get down there, you should get down and take a look at the files?
Not that specific, but yes,
What did you tell her?
that, you know, during the regular trial preparation or meeting with the officers as it gets closer to trial, I would do that, but I hadn't done that yet.
So I still kind of understand. Is there like when the police give you something, do they just email it to you, or is there like a list to say, we gave ADA LALLY these documents on this date?
As far as their list,
Yes.
I have no idea what they have.
Okay. So you don't know, as you sit here today, if they have an index of all the things they say they gave to you?
I don't.
Okay. And do you, on the opposite side, have an index of the things you got from them?
It would be contained within those requests, yes.
All right, so at some point, do you print out all your requests and say, okay, let me just make sure I have everything here? I've been requesting something since, December of 2021. I want to make sure I have everything. Do you sit down and do that at some point to make sure everything you requested, you've received?
My general practice would be yes, and that would be as I know we're getting closer to a trial date.
Attorney Scapiccio, it's a little after 11, and we're going to be able to go until about 11:10. And then I have to break because we're going to have to do the motions to suppress on the two other matters. So we need to think about an appropriate time to break. Maybe now is a good time to break, and we need to talk about another date when we can come back and continue the hearing. Okay. Attorney Lally, you can step down. Thank you.
And they didn't continue it. They just didn't.
For the record, I think the defendant's general motion for relevant discovery is docket number 8 in docket number 21, CR 320. That's what we were going to mark as Exhibit 1. It's signed by you, Ms. Capiccio.
It was on behalf of Ms. Gardner.
I don't know. I didn't dig up a motion to join, but in any event, we're talking about what would be otherwise Exhibit 1. It's docket number 8 in the case. All right. Next dates. I would like to have the benefit of your comparison of the old and new, the earlier disclosed and the later disclosed, and how the various items are different.
So,
might I ask also that the court order if they're materially prejudicial to the defendant as we explore discovery?
Yeah, I'm not sure where your microphone is, but if you can, your mic, can you speak right into the mic?
May I also ask the court to order what is materially prejudiced?
Right.
These materials.
Right. It would be helpful to me if you're proceeding on a prejudice argument to know what it is that you contend is prejudicially late disclosed. Okay. And
might take a little longer, Judge, because last Thursday, we got some additional discovery from the Commonwealth.
Well, let's start in tranches. Okay, we can deal with April, and then we can deal with May.
Okay.
And we have.
And then remember the next hearing they came back and he was all mad because they didn't have the chart finished, and he has never continued the hearing since then. So this was July 21st, and then what had happened was on the 25th they came back to review status, but I think that was on the federal materials with all the other cases. And then he continued it August 12th, and that was a non-evidentiary hearing to dismiss. And it's never been rescheduled. And he was mad about the chart. And then he was like, well, you can't really show prejudice, right? Am I remembering correctly? Let's let this just play out for the few more minutes. Because if it's all scheduling.
Have to deal with it in parts. We can deal with it in parts.
Sure, you're right.
But I don't know how much time it's going to take for the parties to get together on this, and I don't know how far out we should look at a date.
And as far as the time frame for the material, how about when counsel filed the motion? Up until that point, I'm not going to.
Mr. McGee is suggesting that which of the documents produced as of the time you filed the motion for sanctions or to dismiss, do you now view as prejudicial? That is to say, and frankly, how you were prejudiced, okay? This is a witness who's deceased, or we have no way of following up on this, or whatever it is.
Unbelievable.
Okay?
That's only part of the other, I don't want to not meet before that.
Will be.
Oh, he realizes that.
I would like you to do a week, spend a week to try to get back and forth together on these. There's a long list, but it's not voluminous. You can deal with it. You've been through these documents. Each side has been through the documents.
Sure.
So hopefully you can come up with a list. And I'm happy to give you a date when we.
And it just never happened. You guys know because you were there. If you're curious to go watch the hearing after this one, it's on my channel. It's in the playlist of Myles King. And it never happened. It just never happened. It just magically disappeared. Thanks, Stacy, for becoming a new member. Bridget says, now that Proctor's phone is not protected, all these lawyers should fight for all of Proctor's phone information. I hope so. And I know they will from today's breaking news. Fingers crossed. Proctor he's not just been rehomed. He's been delawyered. His lawyer quit. The lawyer's like, I'm out of here. I'm out of here. Thank you, Bridget. That came through twice, actually. So thank you for both of your super chats. Cynthia 1880, thank you for your super sticker. Quinn says it's been 90 days and LALLY is still ADA after all this mess. This is so much bigger than we know. DB Roach says, nope, this is like a dog and pony show. Can't wait for the next hearing when Rosemary has an official roasting party. But I don't think LALLY's ever going to get on the stand. This was 90 days ago. It's never been rescheduled. A lot of people think that Judge Krupp is trying to protect the Commonwealth. I don't know. Denise Go Blue says, I have ADHD and I keep notes and files on everything. I document phone calls and have a color-coded day planner. This is pure laziness, not caring, or cover up. Well done. Look, Scottish One is in here from Iceland. Tell me more about Iceland. I'm thinking about going on vacation there. I've heard it's a really great place to visit. Nope, nobody's stepping in to fix all this. Absolutely not. Amanda says, I always knew my Shih Tzu was smart. I came home from errands and lucky my pups was watching. Melanie, well, look at this. Look at this. We have a mascot now because one of our viewers, Luna's mom, sent me a picture of her cat, Luna, who doesn't like to watch television unless it's my channel, and said, can I make a motion to have Luna be the mascot? And so here you go. Here's Luna only watching me. That's all Luna does is only watch me on TV. She's a real smart cat. Oh, look, there's me and Billy Bush over here. And, oh, wow, these are even old streams. Dr. Russell on the stand, Mark Betterow and I, going all the way back into the heavy archive. So welcome to Luna, our new mascot. And how cute is that? A lot of you guys send me pictures of your pets watching me all the time. And apparently pets love me. So Amanda, your Shih Tzu is awesome too. And so there's that. James says, we all know LALLY has no best practice. Love Rosemary, but not more than Melanie Little. Oh, thank you so much. Leave the drama at the door, says they made it. Just got home, been listening all day. I'm glad you got home safely and leave the drama at the door. Also gifted a membership. Maybe Proctor's all set money-wise. No, I don't think so. I think whatever happened is so damaging that he had to give up the fight. He had to give up the fight. He's not going to get his job back. He's just not. And so I think he saw the writing on the wall. Not only that, who knows what could happen with maybe some of his cronies, buddies, bosses, higher ups. Welcher's emotional support laptop. Thank you so much. If you are blocked, you need to send me an email with your channel link in the email. I can't do anything without your channel link. Yeah, you missed chatting. I don't know. YouTube's been doing that to people. It's been doing it to people. Deanne, same. I need, if it's been happening to you, then I also need you to send me a link to your channel. Even if you think you don't have a link, You do. Ask Carol, because it happened to her, and I fixed it. And according to the payroll, LALLY is still being paid through October 4th of 2025. So he's there. They get paid every 2 weeks, apparently. And his base pay for 2025 is apparently $120,428. Thank you to the viewer who may not want to be named who sent me this. So he's been working there for 20 years as an attorney, and he's only making 120 grand a year. I mean, I'm sorry, but in real dollar lawyer money, that's nothing. That is chump change. You can't survive in Norfolk County on 120 grand a year. You guys live there. Tell me. After taxes? That's insane. And then Hank Brennan got paid how much money? How much money? 600 for not even a year's worth of work? How pissed off is Adam Lally right now? The Vietnam flight is all booked and London Bridge is falling down, falling down, falling down. How many OGs do I have here? Any OGs that have been following me since my first live stream? If you've been following me since my first live stream in July of 2023, tell me what the topic was of my first live stream. Let's see who gets it first. All right, Nancy, you're all set. Nope, wasn't Maya. It was not Maya. Tell me something good. Remember, I did my first live stream. I'm like, nobody's going to be watching except for like my kids and my mother. Yep, it was Kevin Costner. Iceman remembers. It was Kevin Costner. Kevin Costner's divorce. Well, did you see what happened over the weekend? The ex-wife who wanted, the $500,000 in child support, she got married to Kevin Costner's best friend. And remember, there were pictures floating around of them in Hawaii together. She married him. He was Kevin Costner's ex-best friend. And people got the exclusive. Because we've come full circle, my friends. We've come full circle. It's so disgusting. It's so disgusting. Tell us you're not a gold digger. You're a gold digger. Hey, Joshy, I think his name is Joshy. Let's see, Christine Baumgardner marries financier Josh Connor in romantic Santa Barbara wedding. There wasn't a dry eye in the house. No, there wasn't. And there's the happy couple. Hey, Josh, I hope you got a prenup. He's like a bazillionaire or something. They were in Hawaii together. Some pictures surfaced, remember, of them in Hawaii together. And they just got married over the weekend at the Santa Ynez Ranch in Santa Barbara. Surrounded by just over 100 of their closest friends and family. And remember what happened with her prenup. She wanted it set aside. And I don't remember exactly what the final numbers were on what she was getting monthly, but it was a lot less than I think she wanted 260 grand a month to begin with. And I think it wound up being something like 60. Right? We've come full circle, my friends. I thought you would find that interesting. So there's that. So she won't be needing Kevin's money. Yeah, but she's still going to be getting it. And to think she was banging his best friend the whole time he was away filming the Horizon movies, remember? No class, none. But you know what? She hooked up to the next money tree. Hooked up to the next money tree, but quick. Because that was 2023 that I was covering that, and it's only 2 years later. And their divorce was settled relatively quickly in the celebrity divorce arena, banging his best friend. Were they banging? Remember that? That was like in some text messages. Yeah, just look at Kevin's money because it's child support. It's child support. And they do have 3 children together. And so there's that. His best friend is absolutely a slime ball too. 100%. But it's ironic that this just happened this weekend, and it was the first thing I ever covered on the channel was Kevin Costner's divorce. Yeah, most of it's child support. And then because the prenup said that if in the event of a divorce, she had to leave the marital home because he owned the home before the marriage and she wouldn't leave. She became a squatter. That's crazy to think about. That was like July 2023. So it was a little over 2 years ago. Crazy. Crazy, right? All right. It's been a good 4 hours. It's been a lot of fun, you guys. We had some great fun. Music to Myself says, Lally, basically, how should I know the MSP's policies and procedures? I don't even know the NC, the Norfolk County District Attorney's offices. Right. Laura, thank you. I think Duty Ron for sharing Melanie with us. Yeah, I used to co-host with him when Ed was on assignment all the way back in the day. Look how far we've come, my friends. We've come so far. Look at how far we've come. So, big news of the day. Proctor withdrew his, his appeal to try and get his job back in front of the commission. So, we've got tomorrow free. Tomorrow, Wednesday, Thursday. And I want to do a whole Oklahoma stream because Granny, Tiffany Adams, pled guilty. She pled no contest, but she's going to be sentenced in the missing Kansas moms case of Veronica Butler and Jillian Kelly. And also the crazy story on that OSU football coaches, or he used to coach for OSU. His son and what he did to a couple of girls, and now he's getting away scot-free. It's wild. All right. Do all the things that YouTube likes, please. Smash the like button, hit the subscribe button. It's free. Comment respectfully. Go out there and be nice to people. And thank you, Sherilyn, for your Cash App. And she says, you're simply the best. No, you are. No, you are. I'll see you tomorrow. I'm not sure what time yet. Maybe around 11. Maybe around 11 or 12. And thank you all for spending the day with me. I love you guys with all of my heart. And if I don't see you soon, I'm going to die. But I am going to see you tomorrow. I'm going to see you tomorrow. And we're going to cover lots and things and stuff. Thanks for hanging out. Oh, Norman's here. Thanks for your 20. Can you say happy birthday to my sister? My sister, Mitchell Corey. Hi. Happy birthday, Mitchell Corey. Happy birthday. Her birthday is the 23rd. Today's the 20th. So I'll say happy early birthday to her. Happy early birthday from me and from Norman. And maybe she's watching. Thanks, Norman. And James says, am I in trouble with the yellow cupcake? What do you mean? I don't think so. I do not know. I don't know what you mean. Yellow cupcakes are good. If your cupcake changed color, it means you've been a member for longer. I forget what the first color is. Like if you got gifted a membership, you get the first color, and then after 1 month, you get a different color. And then if you're over 1 year, you get the red velvet cupcake, which has the red bottom and the chocolate top. So everyone who has the red velvet cupcake has been here for over a year. So if your cupcake changed to yellow, that's a good thing. Okay. It's lemon. It's the lemon cupcake. I love lemon cupcakes. I do. I love them with all of my heart. All right, guys, stay cool, stay kind, stay classy, and stay safe out there. Don't listen to the noise. They're just trying to distract you from important things like injustices and, maybe Michael Proctor and what's on his cell phone. Don't fall for it because you're better than that. Peace out.